examination is conducted by Ramsar. Lecture 2.
Yes, Lordship. Page 14, I kindly come to page 55, question number 96. Option C is the correct answer, Lordship, as per Ambrose Dictionary.
You call the second, the counsel for Ramsar. You see, there is an order to reflect his name is not reflected. You should have told him that the matter is listed today. 1/3/2023, we passed an order to show the name of standing counsel Ramsar. You should have told him. SC Ramsar, RMSA. SC Ramsar, RMSA. After some time, let them come.
For hearing.
Who is the counsel for Ramsar, Mr. Sharma? Okay, it's okay. Okay, let the name is called. Let us see, let the name is called. Okay.
Item number 5 for hearing.
Okay.
Yeah. My lord, in this case,
Let us begin the hearing. Let him come.
my lord, one submission. We have filed a short amendment petition due to some development. So we did not find the one that day to serve copy. So just now I am serving copy to them, and it may kindly to be brought on record. We have filed it on 26/4.
Unless you give a memo, it will not come.
You can take all the signature.
Okay, then I'll have to adjourn it.
I have served copy. I have served copy to them, my lord, just now.
Okay.
Because on the day of filing, they will not have-
All sides are duly represented. Mr. M.U. Mahmood, learned counsel for the petitioner, submits that he has filed an interrogatory application for amendment of the writ petition, and a copy thereof has been served in court to Mr. S. Bhuyal and standing counsel for higher education, and you have got it.
I have received.
And Mr. Ellen Hingiel and counsel for respondent number 5. Let the copies thereof be also served on the learned counsel for respondent numbers 3 and 4 in course of the day. Next paragraph. Issue notice on the although the interlocutory application is not on record, in view of the submissions made by learned counsel for the petitioner, letter notice be issued on the interlocutory prayer on the prayer for amendment. So, response within 2 weeks. This is the matter after 2 weeks in the orders column.
Taken signature.
6 to 9.
Just a moment, Mr. Mahmood. What is the prayer for adjournment? What is the nature of prayer for adjournment for the
Amendment.
amendment? What is
Yes,
that?
my lord, earlier there was the process was going on. But thereafter recommendation has been sent to the director for appointment of respondent number 5. So that was earlier not. So that is the only limited, very short and without changing the character of the case.
My lord, there are altogether, my lord, 5 affidavits, my lord, filed by the petitioner, my lord. And now, my lord, they, at the time of hearing, my lord, they, my lord, amend the, my lord, the prayer, my lord.
No, you give an objection,
Lordship, lordship.
because you see, you have a point. You have a point, you
Yes.
you give it an objection. You file a short objection.
Lord, sir, item 6 and 9 don't have for timing lesson, go will come.
Okay.
Obliged, Lord, sir.
I think this will take some time.
Yes.
This will take some time.
Four petitions.
For petition, can I start the hearing?
Let him.
Okay,
Continue, Lord, sir.
Okay.
Obliged, Lord, sir.
Item number 10,
6 and 9.
After some time.
So item 10, Lord, sir.
10.
It's also timing, Lord, sir. Go will come. Lord, sir.
Part two.
part 2 hearing
Don't
list,
be so serious at 10:30.
No, he said, he has got matters, like, he was free by this time, the matters in. So.
Mr. Nath, we always appreciate lawyers who are
No, I-
busy.
part 2 hearing list, item number 48 and 50.
Item
48, 49.
Mr. J.C. Bora. Are both sides ready in any matter, part two?
My lord, 53, my lord had fixed it today. Today means, my lord, on that, it was in that list also. But Mr. Sahiwala sir is appearing. I'll just see, my
Just
lord,
find
whether
it
he is there.
out.
If he is there, we'll do it, my lord, otherwise.
Because being unemployed at 10:30 is painful.
The lordship, today it seems to be, my lord, not meeting up. Happens sometimes.
No, I'm intentionally keeping these days free. That,
Lordship, for part two matters.
for part two matters.
Lordship.
50,
Not a presentation from any side. Matter will be taken up in the next.
51,
Speed work show kudese. Speed work show kudese.
52,
Here comes to Goway. You do that matters. Part one matters. You'll do part one matters. Okay.
Item number.
That's 8, 9, 10 or something, 7, 8, 9. At one.
6 to 9.
Yes, Mr. Nath.
My lord, in this writ petition, there are two lecturers, two petitioners, those who are lecturer in Maibong College, my lord. In this case, we have challenged this particular order. Lordship may kindly peruse that order, page number 76. Annexure 21. Dated 29th March 2016. It was issued by the Additional Director of Education to the Principal Maibong College. Subject formal approval of appointment of teaching staff, page 76. Lordship has got it, my lord.
Just a moment. Basically, you are wanting the what you call selection grade pay and increments.
Increment, yeah, these are the two things, my lord. So by this impugn order, the
Page,
status
page,
quo, page
page
number 76.
76.
Order dated 29th March 2016. Annexure 21.
Yes,
My petitioner, sir, at serial number 2 and 4. 2 is Arup Kumar Deka, 4 is Mrs. Junu Devi. Okay. Okay. In other three cases, my lord, today is in the list, in respect of there is serial number 1, 3, and 5. 5. So basically from
just
1 to
just a moment.
yes.
Yes,
So in the series, the serial number 1 to 5, my lord, we are the petitioners today. I am in respect of 2 and 4, and my learned in the council is for 1, 3, and 5, my lord. So you have challenge here. So for the Arup Kumar Deka, serial number 2 is concerned, the remark portion, my lord. Placement in the senior scale to be reviewed and rectified. Status quo to be maintained as regards increment. Same thing in respect of Junu Devi also, next serial number 4. Status quo to be maintained, next increment to be held as per such and such, my lord.
yes.
Now, let me place the fact of this case, my lord. Lordship, please come to page number 18. The appointment letter,
Where is the
page number
government,
18.
where is the government memorandum of 10/7/2015?
10/7, page number 63.
63.
Page number 63. In short, the crux of the matter is, my lord, if the petitioners have got at the time of appointment or later on, if they have cleared NET, SLAT, or PhD, they'll get the increment from the date they qualify. That's what the case is. Now, in so far these petitioners are concerned, my lord, when we were appointed in 2001, from 2001 till date, my lord, we don't have NET or SLAT or PhD degree, my lord. But we are continuing in the post,
You are in the rank of assistant professor.
assistant professor, yes.
Yes,
My lord. Lordship, may please come to page number 18, my appointment letter. Let's start from that. Proper fact, let me please. Page number 18, annexure 1. Dated 21st February 2001. The petitioner number 1 was appointed on this date, my lord. Subject to discharge without assigning any reason, therefore, Miss Junu Devi is appointed as lecturer in English in this college in a consolidated scale of rupees 1,500 only per month.
okay.
The term of appointment is purely temporary and may be terminated if and when situation arises without any prior information. Permanency of the service will depend on the satisfaction of the performance of the service. That's what, my lord. These are issued by the principal, Maibong Degree College, Maibong.
Yes,
Similar term in respect of petition number 2, that's in page number 19. Similar appointment letter, scale of page 1500, rest conditions are same. So lordship can find one thing here. This was in the year 2001 when I was appointed. It was a private venture stage. There is no condition while appointing us that you have to pass NET, SLAT, or you have to qualify PhD degree, you have to obtain. All these things are not there, my lord. The only it says permanency of the service will depend on the satisfaction of the performance of the service. So far our performance is concerned, till today there is no adverse remark, nothing has been. No development proceeding, nothing else, any of this kind, my lord. Now, my lord, lordship, may please come to page number 24. The college was brought under deficit grant in aid system. Page number 24, annexure 5. Dated 29 September 2001.
yes,
Here, my lord, our appointment has been provisionally approved. Let me read these paragraphs, my lord. This is to the principal by additional director of education. In inviting a reference to the subject cited above, I have the honor to state that government have been pleased to take over the Maibong Degree College at Maibong in NC Hills district under deficit system of grant in aid with effect from 1/4/2001. The appointment by government notification dated such. The appointment of incumbents holding the post of lecturer in the different department fulfilling the present UGC norms for appointment as lecturer as shown in statement 1 included here are hereby provisionally approved with effect from 1/4/2001 against the sanctioned post. As such, the appointment of the incumbents holding the post of non-teaching staff, we are not concerned, my lord. Let us skip this paragraph. Next.
Yes,
Page 25. The vacant post may be filled up after observing all formalities as per UGC guidelines and departmental procedure. We are not concerned because our post has been filled up. These are the new, if somebody's, they want to appoint for them. Now, middle paragraph. All the lecturers must fulfill the required conditions laid down by the UGC for obtaining next higher scale under UGC scheme, for obtaining next highest in due time. It has been repeated, in fact. Otherwise, they will not be allowed the above mentioned higher scale during their service period. It may be noted that here, the approval of the appointment is provisional. As such, necessary proposal for formal appointment of all teaching and teaching staff should invariably be submitted to this office along with the under mentioned documents. Now, if your lordship find these documents, my lord, this is what kindly see. GB's resolution for regularization of the appointment under deficit system granting need with effect from 1/4/2001. Copies of all certificates and mark sheet of the incumbent duly attested by gazetted officer, original certificate of the incumbents. Now, if your lordship see next, medical certificate, police verification on the character of the incumbents and permanent residential certificates as the case may be. Now, if we see this clause 1, 2, 3, 4 here, this paragraph says, as such, necessary proposal for formal approval of appointment for all teaching, non-teaching staff should invariably submitted to this office along with. So if these documents are submitted, it will be, my lord, formal approval will be given. That one. Here you lordship will find it doesn't say about NET, SLATE certificate or the PhD, nothing. This certificate, we have this one, my lord. Next, my lord, please come
no,
to
it only says UGC norms.
UGC norms. Now, we have checked out UGC norms. UGC norms, my lord, you will find in the net, lordship will find, my lord, 55% marks and NET SLATE now. That's the one. Now, even in the entire case, my lord, lordship will find, I don't have NET and SLATE, I don't have PhD. That's true. There's no doubt about it. Now, in 2001, when I was appointed, till today, you lordship has seen this paper just now I have read, but if furnish these 4 documents for formal approval. We have got annual increment. Page 32. Can you have a look at page 32? We got our formal increment. Page number 32, Annexure 7. With reference to your letter cited above, as referred to the Director of Higher Education Assam, number sons, the following lecturers of Maibang College are hereby allowed to draw annual increment as admissible on the rules. Number 1, Junu Devi is my client, and 6 is Arup Deka, petition number 2 here. So these 2 persons, my lord, they have got. Yes, and other petitioners are also in this list. All 5 petitioners are in this list. So we have been given, my lord, that annual increment. Now comes, my lord, office memorandum, page number 34. Which one is disturbing us, my lord? This dated 2nd of June 2004. Mandatory requirement of clearance of NET and SLATE for appointment of lecturers. My lord, it was clarified by the government of Assam that as per communication dated 15/12/88, all appointments to be made from the date 15/12/88 should be in observance of the norms laid down by Government of India, Ministry of Human Resource Development, Department such, a letter of even number regarding recruitment of lecture, etc. Second paragraph, my lord. Para 3 of this notification provided that minimum requirements of a good academic record 50% of the marks in master's level and qualifying in the national eligibility test or an accredited test shall remain for the appointment of lecturers. It further provided that it would be optional for the university to exempt PhD holders from NET or to require NET in their case as desirable or essential qualification for appointment as lecturers in the university department and colleges. Further, para such provided relaxation of 5%, that's a different issue. Next, my lord, next page. I'll read the relevant part. Yes. B. 5B.
5C, that is,
5C, no lecturers appointed. No, even 5B is also, my lord. Or let me read also. Let us see, my lord. All the candidates appointed as lecturers on regular basis on or after 1998 must clear net slate by the time mentioned in their appointment letter, or if no time is mentioned in the appointment letter, and if no time is mentioned in the appointment order by December 5. In my appointment letter, my lord, nothing is there. No time is mentioned in my appointment letter. So in fact, they did not alert us, my lord, in fact, that you have to clear this net slate, or you have to obtain the PhD to benefit to get this, my lord. No increment will be granted to such lecturers until and unless they qualify net slate by December 2005. Besides, if the condition of the requirement of qualifying net slate has been explicitly mentioned in their appointment letter, such candidates failing to qualify net slate by the stipulated time shall also be liable to be terminated from the service. My lord, this is what in my appointment letter you have seen, my lord, nothing is there. C, no lecturer appointed on or after 98 and who is not otherwise exempted from qualifying net slate will be eligible for consideration for placement in senior scale without net slate clearance, my lord. No lecturer appointed such and who is not otherwise exempted from qualifying. Now, lordship may kindly come to even 6 also. Let me read, my lord. Candidates appointed by Government of Assam as lecturers in government colleges initially such and such, but confirmed subsequently, are exempted from clearing net slate. Further, a candidate who has been working on a regular basis in a government college deficit granting it against a varied sanction post from a date prior to 98 shall not be required. My lord, we are not on that because we are appointed in 2001. Now, there is a similar office memorandum at page 39, dated 26th of July 2004. Same thing, my lord. Page 39, same thing is repeated.
just now.
Page 39. Same thing, yes. Now, my lord, one important document is at page number 45. Page 45, issued by the Deputy Secretary to the Government of Assam Higher Education Department, dated 28th of December 2005. Page 45, Annex 10. Yeah, oh yes, Commissioner Secretary to the Government of Assam. My lord.
Yes,
The operation of the stipulated condition is laid down in Government OM dated 22/6/04 and 26/7/04. Just now I have referred and I read these two office memorandums regarding clearance of net slate imposed upon the lecturers of college concerned appointed on or after 1998 on regular basis who have to clear net slate by September 2005 is hereby kept in abeyance until further order. My lord, by this order is be kept in abeyance. That means net slate is not the requirement for to obtain this, my lord. Now, to my knowledge, my lord, this kept in abeyance order has not been vacated till today, not modified, not revoked this order, my lord. If that is the case, my lord, in that case, my lord, can we be deprived from getting increment? I think this, they can clarify this question. Because to my knowledge, my lord, there may be, but so far my clients are concerned, they said, no, it hasn't been done, it's not revoked, it's still in existence. Now, my lord, please come to page number 47.
but there are authorities in the judgment of Supreme Court where it says that the requirement of the qualification given in the UGC, etc., they can't be what do you call
Done away with.
Ah. But those are mandatory in nature. That is what
Yes, yes, there are judgments.
we have followed in one of the judgments.
Sushila. One is P. Sushila, I think. P. Sushila. Yes. But it is there's like from the beginning, Lord, she has seen us, my lord. When the case is listed, there's the reason. Anyway, my lord, please come to page 47. Page 47.
47.
Yes. Our service has been confirmed, my lord. They have done everything. In the last moment, that issue has come up. Now, this see kindly, my lord. There's another issue. For not having net and SLAT or the PhD degree, from the day 1, 2001 till today, we are teaching. Is there anything that when we teach the students, there's something is lacking? Nothing. It's just a formal something imposed on this petitioner. This is what, my lord. Suppose the main thing is what, my lord. Main thing is teaching, my lord. They could have said, your honor should be ousted if you don't have.
I don't know, Mr. Nath. It's not for me to comment. But I have seen the new generation mothers. 2 days back also I said in the court. New generation mothers, when they put their children in nursery, then also they are very eager to know what the qualification of the teacher is, what is their mother tongue, what is their language, what is their proficiency, how they will teach nursery student, where the course is ABC for the half yearly, A to Z in the annual.
This is little too much, my lord.
I don't know.
This is little too much. What is that is little too much, my lord. The mother should think about their what education they are having. Then the question.
No, I don't know. But
I'm sure
not for
everybody
me to
not
comment.
PhD there. Some others maybe let's let they having.
My own cousin sister, she has shifted the child now at class 5 to another school because the outdoor activities and the what you call co-curricular activities are not up to the up to her standard.
No, this may be one of the reasons for that. Because when they charge school fees, the mother is right in that respect. Because when they charge school fees, they charge a lot. And when you take the school fees, they don't provide that to the students, my lord. Definitely, my lord. Anybody lost this question? There's no doubt.
No, that's why I said no committees are better.
But better to let us hear from this one. Mali, page 47, kindly have a look. Page 47. Dated 6th of August 2007. Confirmation of service of teaching and nurturing aided employees.
Yes.
My lord, the confirmation of service of teaching, non-teaching staff. The undersigned hereby approve the confirmation of service of the following employees of Maibong College, Maibong, as confirmed by the government body resolution number 2 dated 19305 with immediate effect. Here, Lordship will find my name appears sheet number 14 and 17. Junu Devi and Arup Kumar Deka. And my learned friend's client also appears. Now,
Just a moment, Mr. Nath, just to shorten the process.
yes.
Mr. Gogoi,
Lordship,
just tell me, apart from merit,
Lordship.
on this matter, it's a question which is otherwise in all service law.
Lordship.
There's a requirement that after a few years, there should not be stagnation. That MACP or a assured career progression,
Lordship.
those are normally inherent in the service jurisprudence.
Lordship.
So, assuming that they are not entitled on merit,
Lordship.
Will that ACP or MACP, those things apply
It
here?
is not applicable here. It is applicable as per UGC's regulations, Lordship. We have the grade senior stage 1, stage 2, stage 3.
Okay,
Lordship.
so that is not
That
applicable.
is not here.
Okay,
Lordship.
then we'll hear.
Lordship, Lordship.
Now we have. That is respect that will be senior scale here. I'll show next time. My lord, here our service has been confirmed, my lord, by this letter.
Yes.
Now, Lordship, please come to page number 12, page number 51. They provided senior scale to some of the teachers, including my petition number 2, 20th of February 2009. In persons of government office memorandum 22604, I referred just now, regarding admissibility of senior scale of pay in respect of lecturers of college under the deficit system of grant in aid, the understanding is pleased to allow senior scale of pay of rupees such and such to 14 number of lecturers, Maibong Degree College, Maibong is shown in lecture. Next page is the lecture. Serial number 9 is petition number 2. He has got senior scale of pay.
Yes.
Now, please come to page number 53, my lord.
Yes.
This is one of the letters. Let me read, my lord. 16th of December. That is by the Joint Secretary Government of Assam, Education Department. The Government of Assam in Education Department is pleased to convey its approval that the lecturers of provincialized colleges of Assam having UGC norm and who were appointed on probation against valid sanction post after observing all necessary formalities are entitled to seniority.
This will not apply to you.
No, this is not. From their initial date of appointment. Now I'm trying to show you, this is what they are trying. If they have got norms, then for the initial date of appointment. In my case, it is not there. Now, my lord, please come to page 63. This is another office memorandum of 2015. I've almost take almost, but you'll come to another 2-3. Page 60, dated 10th of July 2015. By this
Yes.
notification, actually, they have clarified the notification of 16th December 2010. That is in page 53. That I referred my office memorandum. They have clarified here. The Government of Assam in the Education Department has observed that questions regarding seniority eligibility of UGC pay scales promotion with regard to the college teachers often kept arising. In this regard, notification dated 16th December 2010 is sometimes misinterpreted, resulting in violation of existing UGC regulations and circulars issued by the Finance Department. It is clarified that services of assistant professors, librarians of provincialized colleges will count towards their seniority from the date of appointment, subject to fulfillment of the following conditions. They must possess, actually should have been possessed, they must possess the requisite UGC norms, including NET, SLAT, PhD, as the case may be. 2, they should have been appointed against valid sanction posts that were vacant at the time of appointment. Our post was, my lord, it was a sanction post. We are regularized. 3, all necessary formalities, procedures as stipulated by the government in respect of appointment should have been followed. Thus, here also no dispute. Thus, only those assistant professor librarians whose appointments satisfy all the above 3 conditions would be entitled to seniority. But that's what, my lord, this document says. Then, my lord, the next page would be, my lord. Then we have submitted representative to the principal, my lord, saying this is our difficulties. Now, please, my lord, kindly come to page number 73. Here I want to show one thing, my lord. Page number 73. Ex post facto approval given by the Education Department. Dated 24th of March 2016. The ex post facto formal approval is hereby accorded to the appointment of the following incumbent of Maibang College, subject to the following terms and conditions mentioned therein. Here, my lord, while typing, I found there is some mistake they've committed. If they tried to like place in one page, that's why. Kindly come to first serial number, then name of the lecturer, then department, post again, which appointment made, date of date of effect of formal approval, date of scale of pay. So we kindly see one Basanta Kumar Singha,
Yes, serial number 6.
serial number 6. He was date of appointment is of 1/4/2001. He has got export approval. Even he has got income and other things, but he did not clear net and slate. Actually, my lord, it is not in the petition, but in the cotton colleges, in other government colleges, my lord, there are so many teachers, they've also retired. They did not have that net slate, but they've got income and all these things, my lord. Although it is not in the petition, but that's what my information is, my lord. And then comes the MP in order, my lord, page number 76. Lordship is seen in the beginning. Order dated 29th of March 2016, where status has been made in respect of increment of these two petitioners and my learned friends clients also, my lord. This. Now we are
Just a moment. This annexure 20, which you are showing me, I'm not being able to follow.
my lord, which one, my
You
lord?
see-
Page number?
That's 73. You see, you have already shown us that there was an approval earlier.
Yes.
After one approval, how can there be a second approval? This is for others. How?
This is
how-
for
how-
others. No, I'm trying to say, this Basanta Kumar Singha.
No, you see, because you see in para 16, you have pleaded that it excludes your names. It includes others, it excludes you.
Initial.
Initial approval is already there.
My lord, one difficulty is there. It is our fault on the part because while writing this paragraph, my lord, so
Okay.
little excuse me for certain.
No, it's okay.
Here and there,
It's
my lord.
okay. It's okay.
Now, my lordship has seen basically now that when we are appointed, we didn't have net slate. Till date, we don't have. We have got service was confirmed. We have got our annual increment, everything we have got. But now, at the fact, how many years now left, my lord? Now we don't have, there's a status code or passed in respect of the increment only. And that, my lord, the senior scale of pay, this thing will come, my lord. Now, the first thing in my appointment letter, there is no condition. They say permanency depends on the satisfaction of the authorities. I'm with full satisfaction, I'm working in the college, my lord. There is no stigma, nothing against me till today. Number two, my lord, even after I was appointed, if these are so harsh conditions, in that case, that if you do not do this in future, this will happen to you. At least the government, what I feel, my lord, they should have written to these lecturers, see, this is what, if you don't do this, you will be deprived, my lord. In that case, probably they could have tried for PhD. Because one of the petitioners, to be very honest, petition number 1, she was telling me, we never knew this thing, there to be so harsh condition in future. But now I have realized, and probably she'll be completing her PhD. I think another 3-4 months, she told me, my lord. But the petition number 2, he said nothing doing, because we are never informed that they will come or fall on us like this in future, my lord. So these are the points, my lord. Facts. I praise your lordship, my lord. Now I leave to you, my learned friend, my lord. if you can throw some stronger light on like this.
It's basically said two judgments. You said earlier also cited. Yes, Mr. Bobai.
Lordship.
Oh, acha, Mr. Nair.
Mr. Nair, might be just it.
He has covered up the things. Only,
No, like,
only one factor, my lord, I would like to place before his lordship. We are all similarly placed, my lord. This decision of the government, my lord, in the impugned letter, my lord would find at page. Yes. 70, my lord will have that only
76.
76, that impugned order dated 29/3/2016.
Yes, yes.
My lord, here they say that there is a government OM of 13/1/2000. Now, this 13/1/2000, in all practical aspect, my lord, in this state,
Yes.
my lord, this 13/1/2000 OM was again clarified in 16/2000. And till that time, my lord, no advertisements that were issued in this state. My lord,
31 to 13/1/2000 was clarified on.
was again, my lord, reiterated on 16/2000.
Yes.
And in the meantime, in between, my lord, the advertisements that were issued did not have this requirement of having a net. This, in all probability, my lord, in the state, came sometime after 2001. My lord, it was in force from 2003 onwards, practically, my lord. Now, Maibong College at that point of time was an aided college.
Yes.
Now, my lord would find that 2000 they issued a notification, 16/2000 they clarified that. But in spite of that position, with regard to persons who were there in service as of 2001, my lord, they were being given their annual increments. There was no dispute on that. Now, my lord, the government, with the passage of time, my lord, realized that this is a mandatory requirement, this has to be brought in. And accordingly, my lord, would find that in 2004, a detailed OM was issued. That 22/6/2004. And lordship would notice one more thing.
Which OM dated?
22/6/2004. Dada, page number kitna tha? I'll just.
It's okay. I have it. Just wanted the date.
22/6/2004. Mandatory requirement of clearance of national eligibility test, state level eligibility test for appointment of lecturers. Now, my lord would find this comes in 22/2/2004. Although, my lord, I'm not denying the fact that in 2000 there was a novice memorandum. But that was not, my lord, strictly implemented. From 2003 onwards, my lord, these disputes arise, and 2004 they come in here. Now, my lord would appreciate one factor, my lord. Without adoption of the UGC norms by the state government, the UGC norms are not automatically applied. That's the stand of the state government all along. Now, they have, in fact, adopted this UGC memorandum of 98 sometime in 2000.
No, you see, that is something which you'll have to explain it to me. What I have read somewhere, I don't, and not immediately recollect now. But it says that UGC norms would not apply if the colleges or universities do not take UGC grants.
My lord, it's the other way. There are two decisions of this. My lord, the law today as it stands today, my lord, from a judgment, unfortunately, I have not carried it today. From a judgment from my lord Gujarat, Gambhir, Vardhan, my lord, sorry, my lord, not carried it.
It's okay.
Therein, but the dispute was like this, my lord. Earlier, it was with regard to that appointment of vice chancellors. My senior also had an opportunity to appear in that case. It went against us, my lord. Wherein it was said that the state government, it's up to the state government. UGC norms would be there. There would be a state act, and the state act would hold the field till the state adopts the UGC norms. If it is adopting it, then my lord, the UGC will hold the field. So that was the law, my lord.
No,
Today it is changed.
The OM says
Lordship.
that OM placed before me in one matter.
Lordship.
It says that once UGC grants are accepted, then it automatically applies.
No, it says, my lord, in the other case, that it would be an extent of denying the grants only, but the action would not be questioned, my lord.
Correct, correct.
Action would not be questioned. But today the law has changed. I'll place that, my lord. Today the law has changed. It said that if there is an UGC notification, it is automatically applied, my lord. We cannot go beyond that. You can't have a contrary thing, my lord. That's the law. But it's with regard to vice chancellor, but that ratio will allow. Now, what has happened here, my lord? These appointments in one of my matters, my lord, he was appointed in 2000 itself. These appointments were with regard to the notification orders of vacancies which were there prior to, my lord, the state government concretizing the adoption of the UGC norms. These posts were advertised for, my lord, and the person was adopted, my lord, in the third case, Tapas Jyoti Borman, my lord, he was appointed in 2000 itself, before 13/6/2000 came into being. And my lord, if my friend can show from records that at that point of time, the advertisements that were being issued, my lord, with the condition that the NETSLET qualification would be there. These, my lord, advertisements came into being after 2003. And from 2004 onwards, it was perfect, my lord. There was no deviation thereafter. But prior to that, there was a period when there was my lord, a whirlpool in that period as to what would be the qualifications to be adopted. In our cases in the hills, my lord, hill region, Maibang College, we were never required, the colleges were never required to advertise posts in that manner. And today, my lord, there are statements made. We have said that there was an advertisement of 2000 and after that selection was made. And in the reply, they say that we have inquired from the principal. A principal said it is not there. That denial, my lord, is not enough. They'll have to bring in some more material to that effect. But be that as it may, if these vacancies were there from 2000, and my lord, these norms were not applied strictly before 2004, then my lord, at the UGC norms prevailing there prior to that. And so, my lord, we were continued. Now, my lord will see the action they have taken. They have, my lord, allowed us to draw annual decrements, which we should not have been. Then, my lord, what they have done is that they have confirmed our services. Now, after having confirmed our services, because, my lord, the OM say that if you are not fulfilling the condition, then you will be a probationer only. Now, in the teeth of those, my lord, you have confirmed our services. And that confirmation still holds the field. Now, with the development of time, my lord, with the passage of time, your thought processes also change. And now, the impugned order has been issued, my lord, sometime in 2016. That was page 76 in that case, my lord. 29/3/2016. Now, my lord would see, they are going back to 13/1/2000. Now, retrospective effect of that 2004 notification cannot be given. If our appointments were made, my lord, DHOS the UGC conditions. It was a case, my lord, wherein our appointments should have been questioned or set aside. Now you can't say we are protecting you. We are not setting it aside. We are protecting you. You are not protecting it us because we don't have a basis. We had the UGC norms on the date, my lord, that was prevalent and then implemented in the state of Assam. And that is why, my lord, we were given confirmation in our services. Now, once confirmed, now, my lord, in your sweet will, you will take up one step after the other. Now, the interesting part is, my lord, these notifications of 2004 and June and July 2004 were kept in abeyance in 2005. 2005, 28, 12, 2005. And this kept in abeyance notification, my lord, is not revoked till date. That is at page 45 of that case, my lord. Look.
Yes.
Now, my lord, the abeyance, those two notifications have been, which were not, my lord, naturally given retrospective effect and affected our cases. My lord, those having been kept in abeyance in 2005, that effect goes, my lord. Now, my lord, we'll see the next step that they have taken. In 2007, they have confirmed our services that my senior has placed before my lord. That is, my lord, 6/8/2007. And now, my lord, now, my lord, in the year 2010, a further notification comes out, my lord. 16/12/2010. My senior had placed it, but I'll just see the, my lord, place it in perspective, my lord, as to what was meant by that, my lord. 53 in that case, my lord. Now, my lord, we'll have that page 53, no? Page 53. No?
Yes.
In 2005, my lord, all these colleges were provincialized, including Maibang College. The government of Assam in Education Higher Department is pleased to convey its approval that the lecturers of provincialized colleges of Assam having UGC norms and who were appointed on probation against valid sanction posts after observing all necessary formalities are entitled to seniority from the initial date of appointment. Now, what it means is, my lord, any person who had the UGC norms at that point of time. My lord, if he did not have the UGC norms, the UGC scale of pay would not have been given to him. He would have got the state scale. We have all got UGC scale of pay, my lord. On the school college being coming under the deficit grants in from 2001 onwards. 1/4/2001. Now, my lord, 2010, as it stands, my lord, is clear that if we had that UGC norms, we were given the UGC scale of pay, and then we were on probation, then, my lord, the seniority will count from the date of our initial appointment. Now, we have to be deemed to be on probation because our services were confirmed by the government. Subsequently, in 2007, my lord. Till 2005, all other OMs, my lord, kept in abeyance. Now, this is what is creating problems, my lord, page 44, 10/7/2015, my lord. That is, my lord, page number 10/7/2015. 63, my lord. Now, my lord would find this. This is issued in clarification of 16/12/2010, my lord. My lord, you have this second paragraph. My lord, they say there is some confusion with 16/12, second paragraph. It is clarified that services of assistant professors, librarians of provincialized college will count towards seniority from the date of appointment subject to the following conditions. Now, my lord, they say they must process the UGC norms, including NET, SLET, PhD as the case may be. My lord, from the date when advertisements were issued, requiring this specification of having NET, SLET or PhD, my lord, this condition is perfectly fine. But my lord would see the notification of 16/12/2010 uses the word UGC norms, which, my lord, we possess as per the advertisement at that point of time. And our services were confirmed. Now we have by now, my lord, put in around 22 years of service, madam. Unblemished, nothing against us, madam. Nothing is there, madam. Getting the annual scale of pay, but now where we are being stopped is that the senior scale and above is being denied to us, madam. Where, by taking recourse to the fact that my lord, it was the government of Assam's fault that it did not in time implement these notifications or UGC guidelines. It gave retrospective effect to everything. But by giving retrospective effect, the things that took place, my lord, in between, that cannot be, my lord, said to be wrong, my lord, because those were done in terms of the norms and practice and procedure being followed at that point of time. And we, my lord, have become a victim of this retrospective effects being given and then requiring us to comply with that. In my humble submission, my lord, and one more, my lord, if that 1/6/2006 lordship would find that the government of Assam, I'll just place that, my lord, once. My lord, the Tapas Jyoti Burman That is, my lord, WPC 4489 2017,
You are referring to 162,000.
160,000.
Yes, which page?
My lord, page 4489 of 2017, my lord. Item number, the last one is.
Yes.
Here, my lord. The notification 16-2000, his appointment is of 3-1-2000. That is, my lord, even before, my lord, page 15, my lord would find. Page 15, my lord.
Page 15 is the appointment order.
Appointment order.
Huh.
My lord, the next notification, page 16, 16-2000.
Huh.
And my lord will also note that 13-1-2000, which they have mentioned in their, in that impugned order, there his name is also there. So 13-1-2000 also, my lord, if it is figured in, this person cannot be attracted because he is of 3-1-2000. Now, by giving retrospective effect to these things, because, my lord, a person appointed in a college, he is in the university system, my lord. They can't say that in the, when we are taking over the college, you will have to process these norms. He is to possess the UGC norms while being appointed in the college itself, my lord, because that college is in the university system. And all these people are exempted in every, my lord, UGC guideline coming into force. There is a specific statement that all persons who are there in the university system hitherto before will not be covered by this notifications or the guidelines or the regulations which come into force from time to time. And the rest facts, my lord, he is also been clubbed with the others, and my lord, the rest facts are the same, my lord. And there is an interim direction here, my lord. In all these cases, my lord, wherein, my lord, the order by which, my lord, 23-3-16 was kept in abeyance.
Yes.
No, humble submission, my lord, these people being in the service, being in the college, during that flux period, my lord, decisions concretizing thereafter must not be made applicable to them retrospectively. This is humble, and they have already spent around 22 years or so.
But just I want to show on paper to you, Lord, please, my lord. There is an affidavit in reply by us filed on 6/11/2019.
Yes.
Lordship has got it, my lord. Please come to page number 11, Annex 2. This is dated 5th of April 2004. school to put the exemption got the so tonight June the so come the the principal agent the government is
When they did not have it. This is in terms of what I have.
Yes.
My God. This is regarding exemption of net slate with reference to the government letter dated 25 February 03 and to assent for issuing annual increment to the following mention 9 numbers of incumbents working as lecturer in table number 2. My lord. Table number 2 is the next page. In table number 2, just above, there are one paragraph, my lord, let me read this one. Mention may be made the following 9 incumbents would also be exempted from a requirement of either net or slate as they have got appointment prior to implementation of the government order dated 25th February 2003. This new circular has notified to all the concerned principals of deficit grant in 8 colleges and thereby ordered to treat either net or slate as compulsory eligible criteria for new appointment of lecturer. The following 9 numbers of incumbents have been appointed prior to enactment of this circular, who could be exempted from clearing net slate, my lord. Henceforth, this could be entitled to receive any increment. Here, my name is serial number 1 and 3. So these are
Konateka 7.
number 1 is Junu Devi
7.
and 3 is Ankur Kumar Das, my
No, you are.
Oru Kumar Taka, yes, 7.
Seven.
Yes, yeah. This is true, my lord. So lordship here also it is very clear, my lord. They've given us the increment, my lord. Now everything remains there. I'm getting this scale of pay as per the UGC norms, everything. Except that particular increment and my lord, senior scale of pay, my lord. There they got stuck up, my lord. After serving for 22 years, and in full satisfaction of the authorities concerned, as mentioned in the appointment letter, performance will depend on the satisfaction of the authorities, my lord. Are we entitled to get the increment? And in between, my lord, there are some refreshing courses, my lord. We have, my lord, done that courses also. For that, that is required for senior scale of pay. Petition number 2 has done that, my lord. So that's what, my lord, my submission is like. 22 years, yes, gone, my lord. Now all of a sudden this. All right, fine.
My lord, I'm sorry to make a mention. My lord, I have a similar matter that is in the hearing list. It's a very old matter. 16 matter. More or less same point, my lord. Here also, because there is no slate, net or slate, my lord, I have been paid fixed salary till date.
Your item number is item number.
Item number 16, my 60 of part.
Yes.
It's some differences there, Lordship, regarding this issue. That's why my seniors has planned the direct recruitment by advertisement, Lordship. At that time, Lordship, when advertisement is issued, Lordship, there is no condition. After that, Lordship, due to the some court cases and other things, his appointment was belatedly done, Lordship. Slight differences there, Lordship.
My lord, actually, my learned friend, he is making a submission. I'm not disputing that. Only thing is, my lord, matter is very simple. The post was advertised in 1998, my lord. My lord, I was the first nominee. I was not given the appointment. I have to challenge because in the meantime, my lord, there was a judgment by the Honorable High Court. And in the meantime, 2003 circular came in. That's the reason until that I'm getting, my lord, fixed pay. Till the other day, I was getting only 8,000 rupees, my lord. Now it has been enhanced to 55,000. And only ground is, my lord, that I didn't have net and slate at the relevant point of time. Though I acquired net and slate subsequently, my lord. I come to this any. So, do you file?
Lordship may hear it separately. If itself today my senior has completed his part, I have no objection, Lordship. I will deliver my argument on Thursday, Lordship, because I have not bring the file today, Lordship. This case is here separately because the issue is
Okay, in that case, my since my learned friend is handicapped, it will be on Thursday, my lord. Okay.
In the morning, please make a mention so that I take up the.
I'll make a
items
mention.
on Thursday, because I may forget otherwise.
My lord, I'll make a mention. Deep.
Yes.
Make with your lordships. Lordship had taken Zunu Devi lordship. Lordship. Yeah, my lord. Lordship may kindly come to lordship. Pair portion lordship in phase 15 lordship.
Just a moment. I'll take a small break and come back.
Lordship.
Because if I don't stand after a long sitting, it gives me some pain in the.
আপনার টেস্ট তো সব বেলেগ কেন আপনার টেস্ট বেটার আপনার টেস্ট বেলেগ Directing the respondent authorities to pay the annual increment to the petitioners, including the selection grade, scale of pay, Lordship. Basically, these three pairs made by the petitioners, Lordship. Now, Lordship, kindly come to Lordship. Annexure 1, Lordship, page 18, Lordship. Lordship, this is a appointment letter issued by the college authority, Lordship.
Yes,
When the college was in the Bhansar stage, Lordship. This, Lordship, Annexure 1, 2, Lordship. All are the appointment letters, Lordship.
yes,
Even, Lordship, the other repetitions also, Lordship, where my senior UPNIR sources mentioned WBC 4489 2017, Lordship. That was also 3rd January 2000, Lordship. It is in Bhansar stage of that particular colleges, Lordship. My lord may kindly come to then, Lordship, next page, Lordship. Annexure 3, page 24, Lordship.
annexure,
Annexure 5, Lordship. Annexure 5, page 24, Lordship.
yes,
Lordship. Lordship, this is a letter dated 29 September 2001, Lordship, whereby, Lordship, the particular Maibong College was, Lordship, taken by the government under deficit granting system of college, Lordship. From that day onwards, Lordship, that particular college was under the jurisdiction of the government of Assam, Lordship. Before
Yes.
that, it was, Lordship, in Bhansar stage, Lordship. Bhansar stage, they have appointed by the college authority, and by the letter dated 29 September 2001, Lordship, government of Assam has taken this particular college, Lordship, under the deficit granting aid system, Lordship. Deficit grants in age systems under the following conditions, Lordship. If Lordship permit, I can read, Lordship.
Just read the relevant part.
Relevant part is that, Lordship. First paragraph, Lordship, last 4 line, Lordship. The appointment of incumbents holding the post of lecturer in the defined department fulfilling of present UGC norms for appointment as lecturer as shown in the statement so and so against the sanctioned post, Lordship. As such, the appointment of incumbents holding the post of non-teaching staff is not required, Lordship. Then, Lordship, next page 25. 20. Second paragraph, Lordship.
Yes.
All the lecturer must fulfill required condition as laid down by UGC for obtaining this next higher scale under the UGC scheme, for obtaining next higher scale under the UGC scheme in due time, otherwise they will not be allowed to above mentioned higher scale Lordship during the service period. This is one of the important conditions, Lordship, when that particular college was taken under the deficient grants in its system of college, Lordship, where it stipulates that, Lordship, for obtaining the higher scale of pay, Lordship, they have to fulfill the UGC's required conditions, Lordship. Now, Lordship, what is the condition, what is the required norms of the UGC at the relevant point of time, Lordship? At the relevant point of time, UGC required norms is, Lordship, as per UGC's regulations 1998, Lordship. If Lordship permit, I can place it, Lordship. Thank you. Lordship, lecturer column, Lordship, where it's clearly stipulated that, Lordship, besides fulfilling the UGC's required 50%, 55% norms, Lordship, the persons have to obtain, Lordship, net
What is it called? Minimum qualification. of-
Lordship. In Lordship, lecturer, Lordship, it is there, Lordship. Besides fulfilling, Lordship, other requirements, Lordship, they have to clear, Lordship, net, Lordship. This is the, Lordship, UGC's regulation force at that relevant point of time, Lordship. On the basis of that particular UGC regulation, Lordship, Government of Assam adopted the, Lordship, that office memorandum was issued, Lordship, on 13 January 2000, Lordship. My Lord, may will get this particular office memorandum in our affidavit, Lordship, affidavit of opposition, filed in, Lordship, Parthojit Bhattacharya's case, Lordship, 4729/2016, Lordship. As per Honorable Court's order, Lordship, we will rely this affidavit, Lordship, in all the cases, Lordship. Affidavit filed by, Lordship, one Sunumoni Das, Lordship, Additional Director of Education,
Yes.
This is the office memorandum lordship dated 13 January 2000. It is an annexure F page 9 lordship. Subject measures recommended by the UGC for maintenance of standards 1998 in the university and colleges lordship. Lordship has already gone through that particular 1990 UGC regulation lordship. On the basis of that particular OM was issued by the government lordship. In pursuance to the recommendations made by the UGC in their notification dated 24/12/1998, the state government has notified revised UGC scale of pay for the teachers of government degree colleges, deficit degree colleges, and non-technical teachers of engineering colleges by notification dated so and so. And the conference of the state government has concurrence, it should be concurrence lordship. Concurrence of the state government has been conveyed for implementation of the revised UGC scale of pay for the universities on so and so lordship. In conformity with the UGC's recommendation, it is necessary to ensure observe the minimum qualification for appointment of teachers in universities and colleges under measures for maintenance of standards 1998 as formulated by the UGC lordship. On the basis of that 1998 regulation lordship, this OM was issued by the government of Assam lordship. And my lord may kindly come to page 11 lordship.
Yes.
Page 11 lordship, lecturer lordship. This is the required qualification as per the UGC's notification dated 1998 lordship. Good academic record with at least 55% of marks or an equivalence grade at a master's degree level or any equivalent degree from any foreign university besides clearing the national eligibility test lordship. This is the mandatory requirement lordship which should be fulfilled by the petitioners. As per the lordship, the notification which was issued by the government of Assam when taking over that particular college lordship under the deficit grants in age system of college lordship. For lordship, next higher grade scale of pay lordship, they have to fulfill the UGC's required norms lordship. The required norms is that lordship, besides fulfilling the 55% of marks lordship, he or she have to acquire the net lordship. And lordship, next is career advancement lecturers. Lecturers will be eligible for placement of senior scale through procedure of selection if CS lordship. A lecturer should be lordship getting the career CS scheme also lordship. He has to fulfill lordship the first criteria to be appointed as a lecturer lordship. For appointment as a lecturer lordship, he should be 55% of marks with the net lordship. The college, when it was taking over by the deficit grants in its system lordship on 29 September 2001 lordship, it's clearly stipulated that lordship, all the lecturers must fulfill the required condition as laid down by the UGC lordship for obtaining next higher scale under the UGC scheme lordship. It is clearly mentioned there lordship. Under that particular conditions lordship, that particular Maibang College was taken over by the government lordship under deficit grants in its system of college. The employees of the college was taken under that particular conditions. They have to fulfill that lordship. If they fulfill, they will get the next higher scale. That is the lordship selection gate, grade 1, grade 2, grade 3 lordship. First of all, lordship, they have the particular college was taken under certain conditions by the government lordship. When it was in venture stage, it was taken that particular employees should be fulfill that particular conditions lordship.
Yes,
Lordship. When the Lordship college was taken over by the government Lordship, that particular OM was put in the field Lordship. The later OM which was Lordship annexed in the petition, it is a clarificatory to the earlier OM dated so and so Lordship. It is a clarificatory. That particular OM Lordship never override the other OM Lordship. It is a clarificatory to the
no, but that was state. Mr. Nair and Mr. Nath said that that was state.
no Lordship.
Once it is state, it was never revived.
No Lordship. It was never state Lordship. It was kept in abeyance Lordship. Kept in abeyance when it was kept in 2003 Lordship. 2003 it was kept in abeyance Lordship. It was not that Lordship. It was state or any Lordship. When the college was under the deficit grant system, grants in age system, college was taken over. That particular OM was very much there Lordship, and their service was taken Lordship on the basis of that particular OM Lordship. It is not a case that was Lordship or sometime it was Lordship kept in abeyance because 1995 UGC regulation is there Lordship, and it was came before the Honorable Apex Court that some one-time measures should be given Lordship who were enrolled before 1991 Lordship. 1991 in the PhD and MPhil Lordship. On that purpose, Honorable Apex Court decide the issue that Lordship who have obtained the MPhil or PhD prior to the cutoff date of 1991, it is 31st March Lordship. They should be exempted. Otherwise, the other conditions which should be required to be fulfilled by any person should be the same. That is 1991 regulation itself says that Lordship, net and slate is required Lordship. At that time, there is no slate Lordship, net is required Lordship. So Lordship, their service was taken by the government on the basis of that Lordship, that particular OM must exist at the relevant point of time. So they have to fulfill it Lordship. It is a conditional takeover this college by the government Lordship. The condition is that Lordship, they for getting the higher scale of pay Lordship, they have to fulfill Lordship that particular conditions Lordship. That particular OM was never put to silence Lordship. That particular order Lordship where 29 September 2001 Lordship, where that particular Maibong College was taken over by the government Lordship. As a deficit grants in the system of college Lordship, that particular notice was, that particular letter was never put to silence by the Lordship, the petitioners and the college authority also Lordship. It is attained finality Lordship. It is attained finality because that particular condition was never silenced Lordship. And the law laid down by the Honorable Apex Court in MP Pavanasami's case is very clear Lordship. When you have to take in the conditions Lordship, you cannot Lordship deviate it from Lordship. It is a conditional Lordship takeover by the college, and it was never silenced by the college at any point of time. Even this particular petition also not silenced Lordship. The paragraph 36 of M. Pavanami's case will be covered Lordship. I will place it Lordship. My lord, 2009 6 SCC 428 Lordship.
2009,
2009 6 SCC 428 Lordship.
name of the parties,
Lordship MP Palanasamy and others versus A. Krishnan and others Lordship. If Lordship permit, I can hand over it Lordship. Paragraph 30 Lordship.
paragraph,
30 Lordship. 30 Lordship.
yes,
Lordship. As per the law laid down by the Honorable Apex Court Lordship, they are bound by the condition stipulated in the letter Lordship, which was issued on 29 September 2001, which is a conditional one Lordship. The condition is that Lordship, for obtaining the higher scale of pay Lordship, they must have to fulfill the UGC's required Lordship norms Lordship. That was never put to silence before the Honorable Court, so even Administrative Tribunal also, it was not silenced Lordship. Nowhere it was silenced Lordship. It is attained finality Lordship. Now, Lordship, my lord may kindly come to our affidavit, Lordship. If Lordship permit, I can place key paragraph, Lordship, if Lordship permit. Then whole facts will be clear, Lordship. Paragraph 5, Lordship. That the University Grounds Commission, in short, UGC, recommended the national eligibility test as an essential requirement for appointment of lecturers in government college in the year 1998. In pursuance to the recommendation made by the UGC, the government of Assam issued office memorandum dated so and so, which made NET as a mandatory requirement for appointment of lecturers in the government degree colleges, deficit degree colleges, and non-technical teachers and engineering colleges. Subsequently, Government of Assam on 1/6/2000 issued a notification thereby making it clear that all the new appointees have to clear NET slate until that if they fulfill the UGC norms and proposes to be appointed, their appointment will be subjected for clear NET and slate. Until then, they would be treated as a probationer and liable to be discharged as if they fail to obtain the clearance of NET and slate. Then, Lordship, paragraph 6, the OM is already Lordship has gone through, Lordship. That the Maibong College was established as a Venture College on 5th September 1998. College was bought under deficit grants in age system by the government by notification dated so and so, Lordship, with effect from 1/4/2001, Lordship. At that time, there were total 13 number of full-time teachers and non-teaching staff were present, out of which 20 were the teaching staff. From 20 norms of teaching staffs, 9 were appointed prior to 24/12/1998. And 11 teachers were appointed after 24/12/1998 and also after 13/1/2000, Lordship. That is after implementation of NET slate as a mandatory requirement for appointment as a lecturer. Again in the year 2003 and after 2025 to 2003, additional 3 norms of lecturers were appointed conditionally against the vacant sanction post. Accordingly, on the basis of the proposal submitted by the principal, in charge of Maibong Degree College, provisional approval accorded to 33 number of teaching and non-teaching staff, Lordship, including the petitioners, Lordship. Thereafter, 7, Lordship, on completion of 1 year from the date of deficit grants in age system of college, the ensuing deponent issued a letter dated so and so Maibong Degree College regarding allowing annual increment to the teachers staff who cleared up the NET and slate by office memorandum dated so and so, Lordship. Thereafter, the principal of Maibong College submitted a proposal for allowing annual increment to the staff who were appointed prior to Iman, and permission was accorded so and so, Lordship. Then, Lordship, paragraph 8. And in the meanwhile, the Director of Higher Education Assam circulated letter dated 25 February 2003 to all the principals of the deficit grants in 8 colleges of the Assam, thereby providing a fresh guidelines by government notification dated so and so to be followed for selection of candidates of lecturers in deficit grants in its system of college. Further, it was also mentioned that NET slate is a compulsory requirement to apply for the post of lecturers and librarians. However, the said letter was misinterpreted by the then additional Director of Education Hills, IC Assam, Haplong, to be a fresh guidelines, Lordship. Superseding the earlier OM dated so and so, he was on the impression that the eligibility criteria fulfilling NET slate shall be applicable with effect from Iman, whereas in fact government of Assam has made it compulsory since 13/1/2000, Lordship. On the basis of the said letter dated so and so, the then office bearer of the additional Director of Education Hills, Assam, Haplong, was of the opinion that lecturer appointed prior to 25/2/2003 were exempted from clearance of NET slate, and henceforth the annual increment were allowed to the rest 10 teaching staff, including the petitioners. Thereafter, by letter and so and so issue additional Director, additional 14 norms, including petitioner placed under which is senior scale of pay. Due to the, Lordship, misinterpretation, Lordship, of the earlier OM, Lordship, the then, Lordship, Director in charge has done this, Lordship. Paragraph 9, Lordship. That thereafter, the Government of Assam Education Department issued a notification dated so and so, thereby conveying approval to the lecturers of provincialized college of Assam having UGC norms and who are appointed on probation against valid sanction posts after observing all formalities are entitled to seniority from the date of the initial appointment. Subsequently, Government of Assam issued the imping office memorandum dated 10/7/2015, where that particular office was put to silence by the petitioners, Lordship, which provides a clear interpretation of the notification dated so and so. It has been mentioned that OM dated demand that only those assistant professors, librarians whose appointments satisfy the conditions mentioned therein would be entitled to seniority from the date of initial appointment, And in case of any assistant professor librarian were initially appointed without net slate PhD or any UGC norms, the seniority of such assistant professor librarians will be counted with effect from the date they secured qualification as per UGC norms, provided they have been appointed against the sanction post lordship. The subsequent to the approach and notification during the process of placement of remaining so and so lecturers, it was discovered that the petitioners along with others was allowed for annual increment UGC scale of pay due to misinterpretation lordship. And misunderstanding of the government guidelines dated so and so includes with the government office letter dated so and so lordship. That particular things was happened lordship due to the misinterpretation created by the then lordship director of Hills lordship. IC director of Hills lordship. It is not a case that lordship at the relevant point of time there was no any net and slate lordship.
No, but strangely you give him the benefit of pay increment and deny
Lordship,
the petitioners.
lordship,
No. Despite he did the mischief.
that was discovered lordship
No, I
later.
understand, but
Yeah.
to that person you are giving increments.
Lordship. That part lordship, I cannot say lordship. Now lordship, page 7 our affidavit lordship. Page 7 lordship, where they have put
Page 7, yes.
page 7 lordship, page 7 of our affidavit, paragraph 23 and 24 is lordship in respect of the impugn order dated lordship 29 March 2016, whereby lordship status was directed to maintain lordship in case of increment lordship. That was also put to silence lordship. That was replied in this lordship. That as regard to the contention raised in paragraph 70 of the ensuing deponent states that formal approval was given only 8 number of lecturers by order dated so and so. Since the 8 lecturers were appointed prior to Iman, so and so lordship before the UGC recommendation of net, whereas the petitioners was appointed after the UGC's recommendation of net and after the implementation of the government OM dated 13/1/2000 lordship. The status quo in the case of petitioner by order dated so and so was issued on the strength of OM dated so and so of the government of Assam Education Department and for review the and notification of placement of senior scale as he does not fulfill the requisite UGC norms lordship. Only that background lordship, that particular lordship letter was issued by the government lordship for status quo should be maintained for review their lordship, placement of the senior scale of pay lordship. That paragraph 25. Regards to the contention raised paragraph 19, ensuring deponent would beg to state that provisional approval of the petitioners were accorded and the benefits of annual UGC scale of pay were also enjoyed by the petitioner only because misinterpretation and misunderstanding of the government guidelines dated so and so by the then office bearer of the respondent of which has been discovered on a later stage. The ensuing deponent further states that the order dated was issued to regularize the matter as per the government office memorandum dated lordship so and so lordship. Only that background, that particular notification is issued lordship. It is an admitted fact that lordship, the petitioners lordship till today have not obtained that particular conditionals lordship, which must be they have to fulfill lordship. That is the requirement of the net lordship. Now PhD also lordship. Net slate and PhD lordship. In addition to net lordship, at present PhD and slate also lordship. They have to fulfill that particular conditions. Then they'll be able to lordship get the UGC's required senior scales of pay and other things.
Now, what is the norms now? Please repeat again. What is the norms?
Now lordship at 1998 lordship, when it was introduced in 1991 itself, not only 1991, in 1978 lordship, Ministry of Human Resource Development Department issued notification lordship where it is stipulated that lordship, besides acquiring 55% of marks lordship, the candidates have to fulfill net lordship. And it was lordship in continuance of 1978 human. I will provide that letter also lordship.
No, what is the current norms?
Lord,
What is the current norms?
current norms is lordship, net as well as slate and PhD lordship.
All three.
All three lordship. If he is obtaining net lordship, then he has fulfilled. If he is obtaining slate lordship, then also he is fulfilled the UGC required norms.
Plus PhD.
Only PhD lordship. Only PhD also lordship he is fulfilled lordship. Any one of three lordship,
Any one of three?
any one of three lordship.
Okay.
Any one of three lordship. Because lordship in 1998 lordship, there is no concept of slate was there lordship. It was firstly implemented by the state of Bihar lordship in lordship 1997 lordship. After that lordship, it was in other states also lordship. So lordship, basic criteria which should be fulfilled by the petitioner for obtaining the UGC's lordship required lordship scale of pay. They have to fulfill the UGC's required prescribed norms, which is lordship net at the relevant point of time when the particular college was taken over by the government of Assam lordship. And 1998 UGC regulations lordship, it was implemented by the government of Assam in 2000 itself lordship. And later lordship, the Office Memorandum 2004 and 3 is a clarificatory to the lordship Office Memorandum dated lordship 2000 lordship. The language is itself clear lordship. Even regarding recently honorable apex, I will place the judgment also lordship. I have not been to that. I will place it lordship. Recently lordship, the one issue was came up before the honorable apex court regarding lordship, the implementation of lordship 2016 UGC's regulation lordship. Then one issue was came up lordship, the UGC's regulation 2016 says that lordship, the PhD is to be lordship verified by the lordship, the persons who have acquired PhD lordship as per 2009 UGC regulations lordship, it should be verified as per 2016, it should be verified by the authority lordship. That was put to silence before the honorable apex court lordship. Then the issue was that lordship, that particular 2016 regulation will be applicable lordship from the date lordship when it was lordship came into force. And honorable apex court says that the UGC's regulation 2016 is a clarificatory to the UGC regulation 2009 and 10 lordship. So it is applicable for the initial date from the 2009 lordship. It is a clarificatory order, there should be a retrospective effect lordship. Clarificatory order, that honorable apex court says that when the order is a clarificatory of the earlier one, it is a retrospective effect lordship. Now lordship, the 2000 Office Memorandum dated 2000 is there lordship. 2000 says the Office Memorandum dated 2000 says that lordship, you should require net lordship. And that condition was lordship never diluted by the government of Assam lordship. We cannot dilute it. It is a minimum required qualification which should be required to be fulfilled for appointment as a person as a lecturer lordship.
Just a minute, you said that 2016 notification
Lordship.
was clarificatory to which notification?
2010 UGC's regulations lordship. I will place the judgment lordship. I will provide the judgment also lordship. It is a clarificatory lordship, and here also lordship, the Office Memorandum 2003 and 4 are the clarificatory Office Memorandum lordship, and 2000 Office Memorandum, that by misinterpreting it by the deed and director of the Hills lordship, he has done this lordship, and it was later came to the knowledge of the authorities. The authority has issued the impugn letter lordship for review of their lordship status lordship. And the letter says that lordship, status could to be maintained, next due increment, help fill up in clearance of UGC's notification dated OM dated so and so lordship. Page 76 lordship.
76 of?
Page 76 of the WPC lordship 4803 of 2016 lordship.
Please come again. What did you say? Please repeat again.
Lordship, page 76 lordship.
Yes,
Page 76 remarks column lordship.
yes.
Status quo to be maintained, next due increment held up till clearance of government OM dated so and so. Government OM dated lordship 2000 stipulates that lordship, the persons have to obtain lordship the UGC's required norms lordship. That particular clause is in page 25 of that particular petition lordship, page 25 lordship. Page 25 lordship, page 25 is there lordship.
Yes.
Lordship, that particular condition was never diluted by the government of Assam, Lordship. Even we cannot dilute it, Lordship. The minimum qualification prescribed by the UGC is the binding to us, Lordship. It cannot be diluted, Lordship. Regarding minimum qualification, there is no questions of adoption or not adoption, Lordship. One have to must fulfill, Lordship, required qualification prescribed by the UGC. Other parties there, adoption parties, other things. Adoption parties regarding the selection criteria, Lordship, what should be there, the constitution of the committee and other things, Lordship. The screening is there, Lordship. Whether that part we have adopted or not, Lordship, it is up to the state, Lordship. Even, Lordship, the recent judgment of the Honorable Appeals Court in Srishnath case. Srishnath case also never diluted the law laid down by the Kalyani Mathivaran, Lordship. In Kalyani Mathivaran case says that, Lordship, until and unless the government has adopted the UGC's required norms, Lordship, it is not binding, Lordship. Here, Lordship, that regarding the eligibility conditions or eligibility qualification, Lordship, we cannot dilute it, Lordship. The state authority cannot dilute the required minimum qualification, Lordship. Required minimum qualification will be binding to us, Lordship. We can enhance it, but we cannot dilute it, Lordship. Required minimum qualification should have to fulfill, Lordship. Because, Lordship, we have to pay them the UGC's scale of pay, Lordship. For obtaining the UGC scale of pay, the persons have to obtain the UGC's required minimum qualification, Lordship. We are not paying from our pocket, Lordship. Because, Lordship, it is a standard given by the UGC, Lordship. They have to fulfill certain criteria, Lordship. Then you have to, Lordship, implement that scheme, Lordship. As per that schemes, you have to give senior scale stage 2, stage 3, Lordship, stage 4 is there, Lordship. It's equivalent to professor under the CS scheme, Lordship. So, Lordship, the persons have to fulfill the UGC's minimum required qualification, Lordship, for getting the UGC's prescribed increment and other benefit, financial benefit, Lordship. Now, Lordship, the recent judgment of the Honorable Apex Court in P. Susila's case, Lordship, the Honorable Apex Court has laid down the law, Lordship.
Will your argument mean
Lordship.
that if the if UGC scale is not availed,
Lordship.
then also the petitioners can stay, but they will get the
State
state
scale
scale
of
of pay.
state scale of pay, Lordship. Lordship has already dealt with the matter regarding one of our colleague Bharti Devi's case with BRM Law College. Lordship has already dealt with the issue also, Lordship. Regarding state scale of pay or UGC scale of pay, Lordship has already dealt with common law college cases, Lordship. In 2000, probably 2018 or 19, Lordship has dealt with 19.
I would not declare. When you say Bharti Devi, I would understand, but I would not recollect the
Lordship.
decision.
Lordship. Even it was reported also.
That was an interim order, Bharti case. Bharti case, there was an interim.
No, no, no.
No, no,
Final.
Matter is still pending.
No.
I dispose it
No,
off.
final. Lordship has already
I
disposed of.
dispose it off.
As per Lordship's directions, contempt case was also filed. That was complied with, Lordship. After it was realized that some mistake is done, Lordship. Then it was again came before the Honorable Court by filing another writ petition, Lordship.
I don't know whether, because she called me the 2 days back.
No, no.
That I told her, "Can I appear for you?"
It is নতুন case, নতুন case.
নতুন
case. Lordship's order, we have complied with, Lordship. After that,
Some mistake.
some,
Okay.
then it was, Lordship, again CS filed, Lordship.
Luckily, no material instruction took place.
So, Lordship, they have to,
No, in fact, he will not be able to take. Mr. Nath, I'll just, I recollect one small story I should share here. I was a lawyer then. A lawyer from Delhi approached for some matter. And he found our names in the net somewhere and approached. So matter was filed and he was insisting that please tell us the fee. I told him that you are a lawyer, you said that you are a lawyer, and the case was about his non-selection in the grade 1. Yeah. So I told him I wouldn't be charging from a lawyer. So he was surprised that somebody is not charging. He says in Delhi we charge. I said that, well, At that time, Three Idiots was not there.
Hmm.
But I told him that, well, my satisfaction would be that when a lawyer opposes, you don't charge. So that will be my remuneration.
That's the practice we have.
You see, after a long time, after 5-6 years of that matter, he once called me up and said that I followed you. He told me to do that. I've done it and I'm informing you that I've
See,
done it.
see the beauty. That's it.
So the lawyer is now again a judicial officer. He is a grade 1 officer, now in a different state.
Yes.
But that is the satisfaction.
Yes, yes, my definitely, definitely.
That is
That's the beauty of our profession.
No, our bar, my lord.
Our bar. It's not there in any other bar.
No, no other,
No other bar.
no other.
In Calcutta bar, they have some regard.
Yes, Calcutta bar is quite.
In Calcutta bar, they have some regard, but not in
Worst
Delhi.
is, I think, Bombay, my lord. I have very bad experience in Bombay. What is the talk at the telephone? Hello, also, my lord. They charge something.
No, because the rentals are very high. If somebody in Bombay is having a chamber quite near the High Court for a
Charges up.
small 5x8 room or 6x8 room, he would be paying a rent of 1 to 1.5 lakh.
But
In Bombay, unless you go, you won't
lord,
understand the.
my lord, but still I
High
find,
cost.
my lord, still I find what happened. Just before 10:30, they called us, they want to talk to the client. So I told my lord, they arrange it, he arranged it. And my lord, next day I found the bill came. Thrice they did it. Then I got disgusted with these Bombay lawyers.
I
Surprisingly, they
won't be
keep
able to
doing it.
comment in specifics, but
By
yes.
force, by force, they want to talk to the client. Just before 10:30, 5 minutes, and the huge bill thrice it came. We got disgusted, my lord, I tell you.
That I won't be able to say, but yes, high rentals are there. High rentals are there,
I
It's
think
a-
that's the reason.
very high rentals. Very high rentals. The stenographers, charges of stenographers there would be also exorbitant. If somebody maintains a lawyer, maintains a steno in the chamber, it will be very costly. I can tell you that. Yes.
Here is a case, Lordship, when we have taken over the college under the deficit granting its system of college with certain conditions that Lordship, he has to fulfill the UGC required qualification, Lordship. One of the matter came up before the honorable court, Lordship. Is a direct recruitment case was there, Lordship. Before that, the appointment of petitioner, Lordship, in 1998, Lordship, 1991, that was also net slate will be required to be fulfilled, Lordship. That was decided by this honorable court, Lordship. Here, Lordship, the paragraph T4, Lordship. T4,
Just a minute.
Lordship.
You give Mr. Nath the citation.
Lordship. It was not reported, Lordship. Whether I reported or not, I have not verified.
Sir, you give me the case number.
WBC 5636/2010.
I'm a high court.
Five 5636/2010, Deepshikha Das. Here also I am relying paragraph 3, 4, 8.2, 7, 9, and 11 also. 9 and 11 also.
Para 9 and 11.
9 and 11 also.
Yes.
T4, 8.2, 9 and 11 also. Even 7 also, paragraph 7 also, Lordship. If Lordship permit, I can read the paragraph, Lordship.
Yes.
Paragraph 3. The recruitment process for a vacancy started with advertisement dated 30/5/1999, and besides a good academic career, the satisfaction of the UGC's norms was stipulated in the interested candidates. The petitioner that advertisement also, Lordship, stipulated the UGC's norms, Lordship. Petitioner did not possess the net slate qualification mandated by the UGC and therefore the Director of Higher Education Assam approve appointment only on the probation basis. The appointee was also expected to secure net and slate qualification, or else she will be terminated. It will be the stipulated approval order dated so and so, Lordship. Following the above approval, the petitioner is appointed on probation basis on 18/9/2000 in the sanction post, but it was stipulated that she would be discharged unless she obtained net and slate qualification. The offer of appointment was accepted by the petitioner and she joined on so and so. But 10 years later, the probationer has filed this case, claims salary at par with other faculty members of the college's, Lordship. 8.2, 7, Lordship, paragraph 7, Lordship.
Yes.
The University Grants Commissions is represented by the Learned Council so and so, and he refers the UGC's notification of revision of pay scale minimum qualifications for appointment of teachers in universities and colleges and other measures of maintenance of standards 1998, Lordship. That was also here, Lordship. To contend that when selection was made by the petitioner was appointed, the UGC's norms applicable for appointment of lecturers is good academic records, 55% of marks at the master's level, and also qualifying the national eligibility test or in aggregated test. Such stipulation is mandatory, and accordingly the council argues that the petitioner, having been appointed on probation basis, cannot demand full salary as she does not satisfy the UGC's norms, Lordship. 8.2, Lordship. The departmental lawyer submits that conditional approval for appointment was granted to the petitioner, as at the relevant time candidates with net slate qualification were not available, but without just satisfaction of UGC norms, full salary of the underqualified lecturers would not be justified, Lordship. Paragraph 9, Lordship. The specification of net slate qualification along with excellent academic career for appointment of faculty members is intended to ensure standard of excellence in higher education, and dilution of requirement would hardly serve the public cause. Right since the date of advertisement so and so till she was appointed, the petitioner was well aware that the UGC norms will have to be satisfied. Without any protest, she accepted the appointment on probation, and which stipulated the requirement of net slate qualification. Here also, Lordship, when the Maibong College was taken under the deficit grants in age system of college, Lordship, it was stipulated that particular condition is that, Lordship, for higher UGC scale of pay, Lordship, they have to fulfill the UGC's required norms, Lordship. Paragraph 11, Lordship. This court is mindful to the fact that the petitioner, on account of stipulation in her appointment order, is drawing lesser salary than her colleagues in the college, but at the same time, the petitioner is not at par with the regular faculty members drawing full salary as they satisfy the UGC norms. To allow drawal of equal pay by the persons without UGC norms would mean treating unequals to equal, and this would be a discriminatory. Therefore, granting relief of equal pay to petitioner would not be justified, and same is declined, Lordship. And paragraph and 12 and 13, Lordship, some procedure is there, Lordship, in the statute books, Lordship. Then Honorable Court says that, but there can be another option for the litigant, as she can avail study leave to acquire the required qualification for the faculty members in the provincialized colleges. The authority to grant study leave in the government and such application are to be rotated through DSC under Rule 23 of the Assam College Assembly Provincialization Rules. However, the applicant must furnish no objection certificate from the governing body if she wishes to apply for study leave, Lordship. Considering the peculiar predicament of the petitioners, Mr. D.P. Solia, the learned senior counsel, submits that if the petitioner applies for study leave, the college management will sympathetically consider the NOC. Regarding, Lordship, Nathan Slade and PhD, if she can do PhD, Lordship. Otherwise, Honorable Court specific findings that, Lordship, we have to fulfill the Nathan Slade, Lordship. That is there in 1998. This case is also there, Lordship. And Honorable Apex Court in P. Susila's case, Lordship. Two 2015 ASCC 1 to 9, Lordship.
Yes.
Here the issue is that lordship, the UGC's required qualification is net slate is mandatory lordship. The UGC has lordship come with a lordship two resolution lordship, 476 and lordship, another is 472 resolution lordship, where they have stated their lordship, they have exempted the PhD holders lordship from net and slate lordship. Then lordship, the matter came up before the Honorable Allahabad High Court lordship. Then it was came before the Honorable Apex Court. On the ground that lordship, in the meantime, central government issued a notification, issued a letter in 2010 lordship, where it says that lordship, for lordship, the standards and excellence of the higher educations, the UGC is bound by the directions given by the central government under section 20 of the UGC Act lordship. The central government negated the proposal lordship, which was whereby exempted the condition of net and slate the persons who have the acquired the PhD degree. Then central government says that the persons have to acquire the net and slate lordship for appointment as a lecturer lordship. When the issues came up before the Honorable Apex Court says that lordship, the directions given by the central government lordship under section 26, under section 20 of the UGC Act is lordship binding to the UGC lordship. If lordship permit, I can place the letter also lordship. That particular letter was put to silence before the Allahabad High Court lordship, and it was came before the lordship, Honorable Apex Court lordship.
Okay, we will not require this here.
Lordship,
We will not require this.
lordship,
here.
just I have indicated the breakdown of the P. Susila's case, lordship. P. Susila's case, Honorable Apex Court says that lordship, net and slate is a mandatory conditions lordship. We cannot lordship dilute it lordship. Paragraph 7, 8, and 9 lordship is the facts. 7, 8, and 9. 11, 12 lordship. It is the opinion of the Honorable Apex Court lordship. And lastly, paragraph 23 lordship.
After 7, 8, and 9.
7, 8, and 9, paragraph 11, 12 lordship.
Yes.
And 13 also lordship, and paragraph 23 lordship. Where the Honorable Court's finding is that lordship, the UGC Act contemplates that such experts body will have to act in accordance with the direction issued by the central government lordship. The central government issued a direction by letter dated so and so, where it is stipulated they have negated the lordship that exemption part lordship. So lordship, from the very beginning, so since lordship 1978 onwards lordship, the Ministry of Human Resource Department 78 onwards stated that lordship, besides fulfilling 50% of marks lordship, they have to net lordship. On the basis of 78 direction of the UGC's Ministry of Human Resource notification, 1991 UGC's regulation is came into force, where it is also stipulated that 50%, 55% of marks along with net. After 1991 lordship, 1998 UGC regulation came into force, where it is also stipulated that lordship, 55% of marks and net lordship. And that was implemented by the government of Assam lordship, by the office memorandum dated lordship 2000 lordship. When the college was under the deficit, taken over as the deficit grant system of well. In view of above lordship, my humble submission is that lordship. When the college was taken over by the lordship, government lordship, under the deficit grant system of college lordship, there is a condition stipulated that lordship for higher grade of pay or higher scale of UGC's pay scale lordship, the persons have to fulfill the UGC's required notification lordship. That was attained finality. That was not put to challenge lordship before any authority of law lordship. It is attained finality. On the basis of that, till today lordship, the petitioners have not fulfilled the required qualification, which should be fulfilled by them lordship for obtaining the UGC's lordship required scale of pay lordship. So lordship, the one authority has some miscalculated it or misinterpreted it lordship. They have given the benefit. Now it was came to the light of the authority lordship. Now they want to revisit it lordship. On the basis of that lordship, they have issued this particular notification, and without fulfilling that lordship, we cannot provide them lordship. Without fulfilling the required norms lordship. This is my humble submission before your lordship. Oblige your lordship.
My lord, I'm appearing NCH, my lord. I'm adopted in.
Okay, you are attempting for, you are appearing for NCLs,
NCL.
autonomous council.
I also filed affidavit, my lord. Is, I'm adopted, is my lord. Nothing.
Your affidavit in opposition is filed in which case?
In my lord,
That was we have
That
relied.
was
That was
by
it.
Mr.
That was relied.
No.
My affidavits are relied by.
We have relied that particular affidavit.
Oh, acha.
We have relied.
Filed by.
It was filed in WPC 4729/2016 lawsuit. And honorable court order is also there lawsuit. That affidavit will be relying all the cases lawsuit. And even we have supplied the copies also lawsuit.
No, that is an affidavit by.
By the lawsuit, additional director lawsuit Hills autonomous.
Okay, so you are adopting it.
Lawsuit, we are, because lawsuit our. Whole government stand was clarified by this affidavit law.
The repetition number is the WVC
4729.
4729 of 2016.
Lordship.
16. Close it, what size?
Okay. Yes, Mr. Nath and Mr.
Lordship.
That's in short, my lord. Next thing. My lord, in the affidavit reply, page number, my reply, page number 12, the paragraph also remember the principal of the college wrote to the addition director. Page number 12.
Yes.
Where it says that net mention may be made, page 12, mention may be made, the following 9 incumbents would also be exempted from net slate. Page number 12.
Yes,
My lordship has seen this.
yes.
They also mention here, government order dated 25 February 2003. Now, this 25th February 2003, please come to my lord page number 45 of my writ petition. It has got connection with that one. That has been kept in abeyance. Page 45, annexure 10 in the writ petition.
Just one.
December.
Yes.
Page 45.
Yes, my lord. The second one, 20 February 03, this particular document is there in the government affidavit in page number 26.
No,
Then I'll come there, my lord. This particular statement that order dated 25th February 03.
Yes.
In my, it is, this particular page is there in page 26 of his affidavit, government affidavit. Filed by Sonomoni Das.
Page 26.
Yes. Two things, two submissions I'll make on that. Page 26. This is by Director of Higher Education Assam to the all principal in charge of deficit grant in 8 colleges of Assam. Fresh guideline to be followed for selection of candidates.
Just one. Yes.
My lord, this letter says to all the principals, subject fresh guideline to be followed for selection of candidates of lecturers in deficit grant in 8 colleges in Assam. With reference to the subject cited above, I have the honor to forward here with a copy of the government notification dated 20th of February 03 for your information and necessary action. Net slate is compulsory requirement to apply for the post of lecturer and librarians. Now, this reference, this is what? Is it prospective or retrospective, my lord? Obviously, this is prospective, my lord. It doesn't say it will come or it will cover up the period before 2003.
Yes.
This is one thing, my lord, they must clear it, my lord. If this is prospective, then this is not applicable to us because we all were appointed in the year 2001. This is my first submission. The second submission is, my lord, my learned friend, in fact, the government is harping on two office memorandums, my lord, dated 22/6/2004 at page 34 and 26/7/2004, page 39. Similar terms and conditions read, my lord. Entire case, they are relying on these two documents, my lord. Net slate is mandatory. Now, these particular two documents have been kept in abeyance 28 December 2005 in page 45 in my writ petition, annexure 10, my lord. Page 45, annexure 10.
Notification issue here. Selection guidelines we issued in 2003. There's not the because
my submission is this is quite relevant, this particular document. The government actually realized, my lord, what has happened and how they've appointed in the colleges which were brought under a grant in aid system, my lord. And there's the reason, my lord, they kept in abeyance this particular document. And in 2003 also, this became prospective. Now, my lord, my learned friend said, no, this was withdrawn. Now, the one simple prayer, my lord, let my learned friend produce this document that this has been revoked or this has been withdrawn, my lord. If this is there, there were different line of things, my lord.
Not said anything in the.
In the affidavit, my lord,
No comment.
specifically, we made a statement regarding this, my lord. But in his affidavit, my lord, I cannot find anything that is even denied, my lord.
It's no.
That is not
It's
there.
okay, but having heard it, I'll not put that question.
Then I think next will be repetition only if we make something. But my learned friend want to finish just by one line, my lord.
My lord, only one factor, my lord. Why this confusion? My lord, 13-1-2000, if it is taken, my lord, if I accept everything, Tapas Jyoti Burman is true. One, my lord, is true. Because his appointment is 6-1-2000. I'm not on that one. In 2013-1-2000, government took out a notification. These are the education criteria. But in the state, my lord, there is a requirement. They issue, my lord, the procedure and the conditions for recruitment. That, my lord, for the first time came in 2003. Now, for the recruitments which have already taken place, you cannot give it retrospective effect, my lord. You can't have a recruitment redone on that basis again. Because all those recruitments that were done without any condition, my lord. Wherever condition has been put, fine, my lord. In that case before this honorable court, my lord, Justice Roy's judgment, my lord, there was a condition put that you must within this period take it or you will be given the minimum scale in the appointment letter. In our letters, my lord, even 2001, we were taken over. We were given the scale, UGC scale, not the state scale, my lord. And we were continuously being given that till 2016. It was in 2016 that the government wakes up. Now, for this period, that procedure having been allowed to continue, now, my lord, can you, by taking a subsequent decision in 2016 of a matter of 2001, my lord, come to this conclusion and deny us the benefits, my lord? Because from 2001 to 2016, this period, my lord, we have lost
Substantial part of our life.
and we were serving there. If we had been indicated that given a letter that no, without doing this, you will not get it, then, my lord, we would have been in some sort of problem at that point of time, my lord. Till 2016, you allow it, my lord. That means for around 15 years, you don't question it. And two things, my lord, we were given approval.
So if you're not getting UGC skill, what study you're drawing now?
Uses skill one with increments, but we are not being given the senior skill. And
No,
the
you refer to 2016. That is why I'm asking that question.
16, my lord, was the why I'm saying so, my lord, that impugn order.
No, yes. So that 2016 will refer it till today.
Till today, I'm getting the increments
UGC skill, okay.
because of the orders of this honorable court. Till 16, I was drawing without orders of the honorable court. 16, they tried to stop it.
Okay, 16 to 23 by orders of.
Orders of this court. There is a stay order. That because this order is under stay, my lord. That 29/3/2016 is under stay. And that is also, my lord, with regard to placement in the senior skill. If my lord comes to that impugn order, page 56. My lord, it would be page, impugn order, 26,
76.
page 76, my lord.
Yes.
My lord, in inviting a reference to a subject matter, I am to inform you that under the purview of the government OM dated 31/20/2000 and so 15, a partial review and rectification is necessary for accordance of formal approval towards appointment of the as per status shown below. Tapas Jyoti Brahman, sociology, status quo to be maintained, next due increments held up till clearance of government OM dated so and so. Then my lord would see Parthajyoti Bhattaji, serial number 3, placement and senior scale to be reviewed and rectified, status quo to be maintained as regards increment as per OM dated so and so 10/7/2015. So, my lord, we were from the date allowed, my lord. Something comes in 2015, you cannot now, my lord, get it retrospective effect. Whereas, my lord, in that appointments made, my lord, for my lord, earlier there was a move that, my lord, that no material are not placed. There was a move, my lord, even persons who were appointed in 2002 were exempted from this because this whole thing, my lord, selection notification, advertisement with net came with that 2003 notification. So my humble submission, my lord, that this 2016 thing is to be interfered with. And whatever benefits we get, my lord, in terms of our service, that is to be released to us, my lord. Senior scale, and then the other benefits, my lord. Because there is nothing against us, my lord, till date.
Here in my case, petition number 2 got senior scale.
I also feel in one of those petitions, that 2016 notification will show, he was given the senior scale. And then they want a rectification. Much obliged.
I'll keep these matters posted on Thursday.
Thursday, for us.
K. Chaudhary would be arguing on that matter. Therefore, I will not be disposing of this.
That matter is lordship defined.
It's okay, but once Mr. Chaudhary says it
Lordship,
is similar,
Yes.
so
Okay.
That matter is a, I'll clarify lordship. That matter direct
no,
recruitment.
no, it's
will
okay.
lordship.
I say I'm not deciding the matter.
Lordship, lordship, lordship.
But when someone says is
Similar.
similar,
My lord will have it.
Lordship,
I'll have it on that day.
lordship, lordship. We have no problem, lordship.
Better for us.
Otherwise, lordship, they have to fulfill the lordship that comes when there is a deficit granting system of police was lordship taken over. Lordship.
The hearing for the matter is concluded. So, heard Mr. Amnath and Mr. UK Nair, and the senior counsel for the petitioners. Who have appeared along with their instructing counsel, the learned instructing counsel, and Mr. K. Gogoi, and standing counsel for the UGC, sorry,
For
for
higher
the
education.
Higher Education Department, and Mr. A. Khanika, and as standing counsel for NCU's Autonomous Council. Next para. It has been submitted at the bar of that. Somewhat similar issue is raised in that was item number 60 in WPC 5779 of 2016, which is in the part 2 list. And slated to be taken up on 4/5/2023.
Good cases. Mine one, those two cases. What is it?
Accordingly, the delivery of orders is adjourned to 4/5/2023. List accordingly. So I'm listing it on
Thursday. Much obliged.
resume at 2 o'clock. Because in 2 minutes, we can't hear any matter. In 2 minutes, we can't hear any matter. So
Lordship, lordship.
resume at 2. We are listing it after 2 weeks. In the meantime, you get us telephone instructions.
No, already they have filed a petition on 17/4, my lord. So honorable court has directed us to dispose the petition within 6 weeks.
6
my
weeks,
lord.
yes.
So, my lord,
No, you are saying that within 2 weeks, the inspector will process it.
yes, my lord.
Because unless I press, the officers will not work. 6 weeks from 24/3 is already over. You are fixing it after 2 weeks, give us updated instructions.
Yes, my lord. Yes.
Ms. P. Bhattacharya, counsel for the petitioner, is present. Mr. U. Sharma, understanding counsel for the
Secondary education.
Secondary Education Department, has submitted that he has received instructions that the matter is now pending for consideration of the inspector of schools. Which place?
Tinsukia, my lord.
Tinsukia. And he expects that he will have updated instructions by 2 weeks. System accordingly. The matter stands adjourned today. list. After 2 weeks, give a date.
19/5.
Obliged, Lordship.
Item number 2.
Lordship, in this case, India's Council, RA Ahmed is necessary hospitalist. Lordship, kindly pass over for the day, Lordship.
Is hospitalized.
Hi, sir.
Okay. It is submitted at the bar that Arya Ahmed Learned Council holding the brief is hospitalized. So accordingly, matter stands adjourned today. List after 2 weeks.
Obliged.
10.
Please, Your Lordship. Your Lordship, my senior is engaged at a part-heart matter in code number 9, Your Lordship. And I apologize, Your Lordship, he was here for a very long time, but the matter was fixed at.
I understand. You listed some other day,
Any date, Your Lordship.
list on, both sides are duly represented, list on. Hearing day, given a hearing day, whenever it's possible.
16/5.
16. Fine.
Deeply obliged, Your Lordship.
Part 2 hearing list. 53, 54.
May I please? My lord, this matter pertains to recruitment to the post of LDA, junior assistant in Jaleshwar Girls High School. Now, before my lord goes into the issues involved, my lord, my challenge was that in the interview component, I was given 0. And the private respondent was, respondent number 6, was given 10 out of 10. Now, in spite of this, he scores marks 0.05 more than me in this election. And my lord, he is put through. Now, what had happened here was, my lord, the I'll just before I take my lot, I'll just give the background involved, my lord, as to exactly what is the issue. Now, my lord, an advertisement was issued under the 2003 rules, my lord. The advertisement was issued on 8/12/2016. Then, my lord, after many postponements, the interview was finally held on 24/1/2016, and therein a select list was prepared. My lord, I get this select list, and therein I find that I was given 0 marks, whereas in all other components, I, my lord, scored much more than him. Then, my lord, I submit a representation. Nothing happens. I come up before your lordship. Your lordship, my lord, examining the matter on 1/2/2016 in the writ petition, my lord, passes an interim direction not to appoint the respondent number 6. Thereafter, my lord, an IA is filed by the respondent number 6, my lord, praying for vacation of that order. This honorable court vacates that order, makes it subject to the outcome of the writ petition. Being agreed, I move the division bench, my lord. The division bench interferes with that order. And then the IA and the, my lord, writ petition is remanded back to your lordship for fresh consideration. They filed a review before the Honorable Division Bench. That review petition was also dismissed. Now, the issue herein is, my lord, after the proceedings, writ petition was filed, the principal comes up and files an affidavit. Therein he says that yes, this petitioner was given 0 marks because in the interview, he was asked questions he could not answer. He behaved in an indecent manner, and thereafter, my lord, he left the interview. Midway. That's the word used, midway. And accordingly, we have given him 0 marks. Now, what happened, my lord? Basing on the selection in that district, my lord, there were many schools where in the selection, many allegations with regard to the school-wise allegations had come up, and these matters went to the deputy commissioner. The deputy commissioner examined each and every allegation of particular school and the other schools together, individually, my lord, and then passed an order after hearing the selection committee members. And therein, my lord, he said, at least 1 mark should have been given. Because they participate in the selection process, marks are there, so 1 mark is to be given. Then what happened, my lord? This was brought before, to the notice of your lordship, by way of filing additional affidavits by the respondent number 6 and by me also. I make further RTI applications before the authorities, my lord, seeking to know as to what were the materials basing on which this was done. What were the statements of the selection committee members? I bring before my lord the statements. This is, my lord, after the affidavits were filed by both sides. In the statement of the selection committee members, they say that they were not knowing the procedure. They were in a hurried manner. They had done the selection process. And accordingly, ignorantly, they had given 0 marks. They should have given some marks at least. This is the statement before the inquiry officer. Before, my lord, these proceedings begin. No whisper that there was any bad behavior on my part, or, my lord, I had left the interview midway. Nothing of that sort, my lord. Now, after getting that affidavit, a further affidavit is filed. No, we were pressurized in that inquiry there, so we had to file. But this statement was never made at any point of time before this aspect. 1, my lord. 2, now that 1 mark is to be given to me is in the interview component. I'll go a step further. I'll have my lord's attention in the, before I take my lord through the pleadings here, I'll have my lord's attention in the rules, 2003 rules. Well, whatever is done has to be done within the purview of these rules. If my lord is holding the same book, it is, my lord, 368. Yes, my lord, 368. And if my lord is satisfied in this, my lord, I need not go into the other aspects. Method of recruitment, my lord. 4A1. Recruitment to the cadre of lower division assistant under Rule 32A2 and in class 4 post under Rule 32B in the office of the higher secondary and multipurpose school shall be made directly by the appointing authority from the select list prepared by the school selection committee constituted under the provisions of Rule 8C on the basis of test and interview. The principal or the headmaster, as the case may be, where the vacancy exists or likely to exist within the next 3 months, shall submit a proposal that my lord can ignore 3 months. After receipt of the list of candidates from the district employment exchange, the principal or the headmaster shall inform the school selection committee to hold the written test for selection of lower division assistant along with typewriting test and written test along with viva voce for class 4 post. Post in consultation with the inspector of the schools. So, my lord, for the post of LDA, the requirement is, my lord, typewriting and written examination. Whereas for the post of grade 4, it is written test along with viva voce. So, my lord, viva voce is not a component contemplated under the rules. Now, this honorable court, my lord, on, if my lord can take up the IA, my lord. IA number 936. Huh? (23) 1/2017 order. Specifically referring to this rules, my lord, required the government to make it stand clear, my lord. 936. Highest civil debt. So, my lord, if the rule does not require the interview component, my lord, any mark given thereto will be inconsequential, my lord. Cannot be taken into consideration because the rules will have to have the primacy, my lord, in any selection process. And if the interview component is, my lord, ignored or left out, I am there. And with more than 9.5 marks, my lord, then the respondent number 6, my lord. Because, my lord, they knew they had the other calculations with them, my lord. So 10 marks, 0 marks. And, my lord, the allegation, okay, my lord, it's not a case that I cannot be given 0 marks or I cannot be given 10 marks. Either possibilities are there. But now giving me 0 marks for the purpose of my conduct and leaving midway, there ought to have been an endorsement in the select list. In absence of an endorsement, it is a development made before this honorable court to cover up that illegality. Your lordship would have, my lord has seen that order. Therein, my lord, there is a requirement that the government will come before your lordship with that stand till they have not disclosed anything, my lord. If that be the position, my lord need not move further. This is enough. The select list, my lord, would find at page 30, my lord, of the writ petition.
So your submission in brief is silence is golden.
Silence is good. My lord.
Good.
Because this is a question of law, my lord. I can take it up at any moment, my lord. My lord would have page 30. I'll just compare, make it compare. Written test was for 70 marks, my lord. I am at serial number 1, I got 25.
You're
He-
referring to where?
My lord, 30. Of
This
the
IA.
writ of the
Writ
writ petition,
petition.
sorry, my lord. Of the writ petition, my lord.
Yes,
My lord, that is the select list.
yes.
Serial number 1 is the petitioner. He gets 25 in the written examination. The respondent number gets 6, gets 23.5. English typing, I get 5, he gets 3. Computer test, I get out of 15, I get 14, he gets 8. Oral, I am given 0. He is given 10. Now, my lord would see the difference. It is, my lord, 44 in my case and 44.5 in his case. 0.5, even with that 10 marks. Now, the rules does not require a holding of an interview, my lord. If the interview component is taken out, I am 44, he is 34.5. And my lord will not find anything. The original, my lord, is at page 31. My lord will not find any endorsement there.
But Mr. Nair,
Lordship.
having gained a little experience in this matters now, I had an opportunity of throwing out extremely oversmart candidate. When the questions were put to him, then only we realized the big void he was having in his head.
It can happen in a selection. It can happen. But if my lord is doing that, not considering, at least my lord might have put a note somewhere in my lord's personal evaluation sheet itself that this is the conduct, because conduct is one. Interview, my lord, is there for conduct also. My lord is examining the man's from all angles, not knowledge. Knowledge is already there. knowledge plus his approach. I'm not saying, my lord, that I am not in a position to do that. I might have done that. But you must make a endorsement to that effect. Now, from this select list itself, it is clear that you were trying to favor the respondent number 6. Because these marks are with you. Now, my lord would come further to the DC's report, my lord, which my lord would find at page 36.
No, but 0 is a consistent figure. When he 0 is given to 3.
They have admitted that. They have admitted that, my lord. My lord will come to page 37. This is the order of the Deputy Commissioner on 11/2/2016, wherein all the complaints of various schools were taken up. 37 is pertaining to me, my lord. My lord, the third paragraph down below, my lord, just above the last paragraph. In just above the words after, the paragraph just above the word after. In case of B above, in Jaleshwar High School, it is seen that 0 marks were awarded to some candidates, namely so-and-so, 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 and full mark to a candidate. Salimuddin Ahmed, which does not show due application of mind by the selection committee. In any case, at least 1 mark should have been given for personal appearance of candidates before the selection committee after crossing all selection criteria. I'm not even for a moment saying that would be a very valid reason to give, my lord. But
We had occasions here in this court. They have turned out officers attending in bush huts. Particular government staff was ordered to meet the highest executive of the state in the apparel he was wearing and came to court.
I know that, man. I know that. I know that. I know that.
So marks for appearance, I don't know.
My lord, recently I had an experience, and I'll tell that something now it's pretty openly with regard to clothes. But I was told, my lord, and therein we had a meeting, my lord. That's rule committee thing. This is B.B. Kotoki sir and Manojit Bhai was there. Somebody had turned up before Justice D.N. Boru sir. He was in the State Commission.
You were turned out.
Somebody went there.
He came in a t-shirt.
No, he went, my lord, in a half shirt.
Half shirt t-shirt,
And
yes.
the bench asked him whether he has come directly from Fancy Bazaar. And it was Justice
I was there.
Amitabh Roy, my lord.
I was there.
Amitabh Roy, sir. And that was intended to me, my lord, because I had come on that day. It was a holiday. So they were all well dressed. I had come, my lord, in a casual dress. So this was directed to me, my lord.
The tradition was that you either wear a gentleman's apparel or the national dress.
National dress. I got it, my lord. I got it. Now, my lord, if your lordship can, my lord has seen 36. My lord may proceed further. To page 53. My lord. That's the affidavit by the respondent number 4 and 5. Page 54, paragraph 5. Go on, second copy to paragraph 5, my lord, page 54.
Just only.
Para 5, my lord, page 54. My lord, this affidavit was received by me on 14/3/2017. My lord will just make a note of that date. My lord, here it says, 1, 2, 3, para 5, Fourth line, my lord. In fact, the petitioner's performance and behavior was totally different than what he has stated in the writ petition. The petitioner failed to give proper reply during the course of interaction in the interview process. Having failed to give proper reply to the questions put to him, the petitioner started to behave in a very indecent manner, my lord will mark these words, and was immodest towards the members of the selection committee. Having failed to give proper reply, the petitioner left the interview process in the midway, which was unbecoming of an employee towards his employer. The petitioner was arrogant in his behavior and attitude, and thus the selection committee, finding the respondent number 6, who has given correct reply to the questions and queries that were put to him, and thus evaluating all the process, pros and cons, selected the respondent number 6 at merit position number 1. Now, my lord would find the allegations made against me here is with regard to my conduct in a selection process. I had not answered the questions, so I was given 0 marks. That would have been a different aspect altogether. Here the allegation is that I misbehaved with them, and my lord, I left the interview halfway, in the midway. Categorical statements, man. If this be so, this has to be reflected in the selection list so that, my lord, the biasness is not there. They'll have to reflect it. I could have countered it, that what you're saying is wrong. You cannot make the statement because I was in a very docile manner before the selection committee. I may not have answered the question. That's a different issue altogether. Then my lord would find what I do is, my lord, I file an RTI apply. And in the RTI application, oh, my lord, before that, my lord may come to page 59 for a second. (59) is a guideline given on 13/11/2015. Here also, the, my lord, prescription in rule 8, rule 4 is reflected, my lord.
Where is it?
My lord, page 59.
59, I'm there.
59, my lord, would come method of recruitment. A, 1, 2, and 3, my lord.
Okay.
3, my lord, after receipt of the candidate, so and so, the principal and headmaster shall inform the school about the hold the written test for selection of so and so along with typewriting test and written test along with viva voce for class 4. So they have, my lord, even gone beyond the instructions that were given to them. Now, my lord, would come to page 61. That is an affidavit filed by me, my lord. On 21/3/2017, herein I had brought on record the RTI reply, my lord, which my lord would find at page 72, vernacular at page 73, my lord. All the selection committee members are there before the court, before the authority, my lord. 72, my lord. With due respect and humble submission, we beg to state that the oral test for so and so. In the set test, we, the 4 people, being unaware about the guideline and also in hurriedness, we could not take decision in proper manner, hence, and we have awarded 0 marks to the first candidate along with 2 others, as they could not answer properly to the question put to them. And hence, by mistake, we awarded 0 marks to them. But in fact, some marks ought to have been given to them. On the other hand, we awarded 10 marks to the second candidate who had given correct answers to the question put to him. It is therefore prayed that Your Honor kindly forgives us for our aforesaid mistake and also conveys our consent to correct this error. So herein, my lord, there is no allegation that I misbehaved. I left the, my lord, interview process midway. So that's the reason why they say in the affidavit that I was given 0 marks. It's not here. Now, my lord, on getting this affidavit, my lord would see this stand. Page 79, it starts. Relevant page 80, my lord. I had to know what is it. No, no, it is. 80 para 2, my lord.
What is the name of respondent number 5?
My lord, the respondent number 5 is the headmaster. Respondent number 4 and respondent number 5 is the headmaster, my lord. Headmaster.
5 is the headmaster.
Headmaster, my lord.
4 is also then headmaster.
No, 4 is also, my lord, headmaster. He is, my lord, actually the school selection committee 4. And 5 is the headmaster. Come member secretary of that school selection committee.
Okay. Yes.
My lord will have page 80, my lord.
Yes.
Para 2. That the deponent begs to state that after the selection process was completed, following the due process, the matter was taken to the district magistrate Golpara on some alleged irregularities, and the school authority were asked to appear before the deputy commissioner. Golpara. My lord has got it.
Yes, yes, I'm there.
The deponent therefore appeared as asked for, and on his appearance along with 2 members, the deponent and the 2 members were asked. It's actually, my lord, not 2 members. There were in total 1, 2, 3. Yes, and 2 members, 3 members. My lord. Were asked as to why the petitioner was given 0 marks in the interview process, and to which the deponent and the members replied that the petitioner did not give answer to questions that were put to him, and he also misbehaved with the members of the selection committee. Now, this is not them. The officer present, who was probably in the rank of so-and-so, the name of whom is not known to the deponent, then spoke in a very high pitch and asked the deponent and the members of the selection committee as to why they have given any law, have with them any law to show 0 marks can be given in interview, to which the deponent and the members replied that they do not come along with such law to show 0 marks can be given. To this, the officer asked the deponent members to write down that they have committed a wrong in allotting 0 marks, or they will face trouble with their service. Thus, being helpless, and as speech of the officer was more than in nature of command, the deponent and the members were left with no other alternative than to give the writing, which was given under duress, and the same was therefore not given voluntarily. Now, my lord, if this was the fact, what prevented them from disclosing that not before any other authority? I've given them that leeway, that they have not appealed to the director, to the commissioner. They have not said that, see, because of these circumstances, we have not been here. They were before a constitutional court. They could have, my lord, when they said that this man was given 0 marks because of his behavior, but see, in the inquiry, we had to give this statement under force.
So you are proposing that in your writ petition, I would venture into that inquiry.
No, I'm not even asking my lord to go into. I'm only asking my lord to judge that stand that they have taken in the affidavit.
A stand is a stand, will adjudicate.
Lordship,
Stand is only a stand, will adjudicate.
adjudicate, but for adjudicating that, I have brought this material, my lord, which is also in form of a writ petition before your lordship, second writ petition, wherein they have challenged the, my lord, the report of the inquiry report of the orders of the deputy commissioner. WPC. There is a second writ petition, madam. WPC 2331 2016. Very good. And Lordship would just have that writ petition, my lord. 2331/2016. Item 54.
I have it.
Have it, my lord would find. It starts from paragraph 11, my lord.
Without hearing.
Without. What is the stand, my lord? So that is a stand development made before this honorable court to justify that illegality. And same is there in paragraph 13 also. my lord. And my lord will note one thing, my lord.
Para 11.
11 and 13, my lord. My lord, a fact in issue that they were, my lord, where they were forced to make that statement, existed on the date when the, my lord, the inquiry by the deputy commissioner took place. The writ petition was filed in 2016. This was not a fact in issue then. It became a fact in issue after I brought the statements on record in May 2017. So, my lord, the biasness of the headmaster in this matter is amply clear, my lord. That coupled with the fact that the interview should not have been held. It should have been ignored. That's the dictum of the law. So, my lord, that interview component has to be left out. And basing on the other part, this election should be taken to its logical conclusion, my lord. This is my humble submission, my lord. And for all this stance, which does not have any connection with one another, I leave it to your lordship, my lord, how my lord would deal with it.
I don't know whether I am right or wrong. I have heard somewhere that the beauty of a judicial dress of black is that nothing sticks.
My lord, with due apology, if I can say something. my lord. When,
No, judicial means I am speaking for
Every-
you and
either
everyone
side.
else, both sides.
my lord, whenever some counsel, junior, my lord, comes up and says, my lord, he's afraid to face the court or something, I just ask him, put your band outside. It will reflect that. They laugh, my lord.
So we wait for Mr. Saiwala. Oh, okay, we'll take up another matter.
Lordship.
My
friend is a selection. I can make my.
Ah, yes, yes.
For the school.
Yes, yes.
Oh, he's the main member.
Lordship, one of the ground taken is that whether interview ought not to have been happened, Lordship. My submission will be having participated in the interview now that he cannot turn around and say that ought not to have been happened. And moreover, Lordship, if your Lordship come to
Very recently, I have dealt with one such matter. And one of my observation was that once somebody faces an interview or any procedure for appointment, selection and appointment, he accepts the legality of it, not the illegality of it. I borrowed it from a Supreme Court judgment. You see, the fact is that X is subjected to interview. X does not know he appears. And then if law does not permit that interview to be held, would it be so, what do you call, it would be so bad that the writ petition be thrown out only because of that? Because if the rule permits and it took place.
Yes, Lordship, rule permits for interview, Lordship. Lordship, can you see method of recruitment, rule 4 of the 2003 rules, Lordship?
Yes.
May I read, Lordship?
Yes, yes.
Recruitment to the cadre of law division assistant under rule 32A2 and class 4 post under rule 32B of in the office of the higher secondary school, higher secondary and multipurpose school shall be made directly by the appointing authority from the select list prepared by the school selection committee constituted under the provision of rule 8C on the basis of test and interview.
Fine.
So interview part is there, Lordship.
My lord will read 3 along.
Now, Lordship may take our affidavit, Lordship.
Because 1 and 3 have to be read together.
Which my senior friend has referred at page 59, Lordship. It also tells about the test and interview, Lordship. That
Just a moment. You are referring where page?
page 59, which my friend has referred, Lordship.
Page
My affidavit will be running page 59,
59.
if I'm not wrong, Lordship.
Affidavit of respondent 4 and 5.
4 and 5, Lordship.
Oh, that would be
Sir.
53.
Starts at 53, my lord, relevant, my senior is referring to 59.
It also tells about the test and interview, Lordship. And Lordship, if it comes to page 52, Lordship,
Page, just a moment. 59. Yes.
now Lordship may refer to come to page 52, Lordship. That is page 6 of my affidavit. The test and interview was held in a neutral venue, Lordship, not in the school, not in my school, Lordship. It was held at PR Government HS and MP School, Gwalpara, and it was constantly monitored by the inspector of school, Lordship. Lordship, file in the second last paragraph. Further, I would like
Page 2.
52.
No, 52 is something else.
This
Your
letter-
affidavit.
This letter of the inspector of schools, Lordship. Addressed to us, Lordship.
No,
Page 6 of my affidavit.
page 6. Okay. Yes, page 6.
The whole interview process, selection process held in a neutral venue, Lordship, in a different school, Lordship. Lordship will find the name of the school, the third paragraph from the bottom, Lordship. In this connection, I'd like to inform you that the typewriting test, computer test, and oral test will be held on so and so at PR Government HS and MP School, Gwalpara. So you are asked to attend along with your selection committee on that day for conducting the same test. Then the second last paragraph, Lordship. Further, I would like to request you kindly to submit the question papers and answer scripts separately on so and so with seal cover of the undersigned. So every steps are monitored by the inspector of school, Lordship. So it was held in a transparent manner, Lordship. Now, Lordship, whether in a given case, Lordship, 0 can be given or not, or whether the deputy commissioner could have interfered in a process and allotted marks, who is not an my superior authority. Lordship, for in that regard, Lordship, for, I'll be relying on a case, Lordship, 2017 2 GLJ, page 451.
কিমান বলে? 2017 to
I'm relying on
2017?
paragraph 11,
2017,
2017 2 GLJ, page 451. Name of the parties is Leena Bora.
পার্টির নাম তো কি তোমার? পার্টির নাম তো কি?
I'm relying on paragraph 11, Lord.
yes, yes, Lina Bora,
Leena Bora, Lord.
রিনা, রিনা,
LEENA.
পার্টির নাম,
Leena Bora
LEENA.
versus State Open.
রিনা,
Leena,
LEENA না?
LEE. Paragraph 11, Lordship. Having regards to the scheme of the selection to the post of junior assistant under 2003 rules as discussed above, it is quite evident that Deputy Commissioner of the concerned district has no role to play in the selection. Hence, is neither a part of the school selection committee nor the appointing authority, neither he has been assigned any supervisory role. In such circumstances, interference by the Deputy Commissioner in the selection process for the post of junior assistant in higher secondary school and high school would be beyond the mandate of 2003 law. As such, interference not contemplated under the said rules. So the Deputy Commissioner could not have asked for the parties to appear and allot a mark, Lordship. Lordship, then the next case I'm relying is Lordship, 1993 supplementary 4 SCC, page 377.
please give the citation again.
1993 supplementary 4 SCC.
Supplementary for assistant. Page the
377.
37.
The name of the party is Hosiar Singh versus State of Haryana. Here also candidate, Lordship, the candidate misbehaved when he was allotted 0 marks, Lordship. The paragraph I'm relying, Lordship, is page. Paragraph 13, Lordship. May I read paragraph 13, Lordship?
Yeah, just one. Yes,
I'm referring paragraph 13, Lordship.
yes,
As regards rejection of candidate on the ground that they had misbehaved at the time of interview, we are unable to agree with the High Court that board could not reject a candidate on the ground that he had misbehaved at the time of interview. In the process of selection, the board is required to adjust the suitability of the candidate for appointment on the post for which selection is being made. The board is entitled to take note of the behavior of the candidate at the time of interview, and if it is found that the behavior is such as to render him not suitable for holding the post for which selection is to be made, the board would be perfectly justified in rejecting him for appointment on the post. If the course suggested by the High Court is adopted, namely that the board may give 0 mark to the candidate who misbehaved at the time of interview, the result would be that a candidate whose behavior was such as to render him unfit for appointment to the post may have to be selected and recommended for appointment on the basis of marks sequenced by him in the written test, although in view of his behavior at the time of interview, the board would that he is not suitable for such appointment. So merely because his written test he has more obtained more mark, Lordship, that can be the basis, Lordship. His behavior at the time of interview has to be, the board is entitled to consider his behavior as a well, lordship, and rightly can reject lordship. The next case, lordship, this is not reported in GLT or GLR. This is case from Tripura, lordship. And the relevant para I'm relying is paragraph 10, lordship.
Yes.
Read paragraph 10, lordship. Coming to the next point, that the petitioner was given less marks in oral interview and the respondent number 3 and 4 were given higher marks, and thereby the petitioner was deprived. I find that in the oral interview, the petitioner was given 10 marks, the student number 3 was given 20 marks, and another Manu Dev Burma was given 10 marks. The respondent number 4 was given 18 marks, another Bibrato Marak was given 15 marks, and other Ranjita Chaudhary was given 17 marks. No doubt the petitioner was given 10 marks out of 25, but that was an assessment made by the duly constituted interview board. The petitioner did not challenge the selection process when the advertisement was made and written examination and oral interview were arranged. The moment he came out unsuccessful, he challenged the appointment of the respondent so and prayed for directing to official respondent to appoint him. So same case is here, lordship. He participated in the interview the moment he has not been selected here. And moreover, lordship, he has not alone who has been given 0. 2 other person has also been given 0. That will lordship find from the blacklist that has been annexed. If your lordship take up the other writ petition, lordship, Annexure 3, page 30. One Ajmal Haq was also given 0. Safikur Rahman was also given 0. 2 other persons were also given 0, lordship. In the other case, I am relying, lordship, it is our High Court judgment revision page, lordship, paragraph 7, I am relying, lordship. May I just read and then I will pass it on, lordship. Thirdly, whether the marks allotted to an interview were more having regard to the nature of the post was a matter of the departmental authorities to decide. And the appellant, having subjected to the interview along with every candidate at par, had no right to turn around and raise a plea, subsequently contending that there was some flaw in the marking system. And lastly, no case of arbitrariness as per could be pointed out by the appellant in the impugned selection process, so as to call for any interference in the impugned order. Lordship. is 2014 4 GLR, page 783. So in my respectful submission, Lordship.
Paragraph,
Seven,
Seven.
Lordship.
yes,
Lordship, so in my respectful submission, Lordship, the selection process has been held under the guidance of the inspector of school, Lordship, in a neutral venue, Lordship. He has participated, Lordship. Lordship, having given 0 marks because of his behavior, he has been unable to answer, Lordship. The deputy commissioner could not have interfered and allot him marks, Lordship. So in view of the matter, Lordship, the writ petition is liable to be rejected. Lordship. That's my humble submission, Lordship.
My lord, here in this case.
yes,
Here in this case, my lord, already my friend argued the case on my behalf also. I adopted also his arguments. And that is why I am not filed affidavit, and I also adopted the affidavit filed by the respondents. Moreover, my IA, it will be also treated as affidavit in oppositions. Earlier it was held that my IA is to be treated as affidavit in opposition. So whether this is an official order or not, I have no knowledge. But it has been observed by the court that my IA will be treated as affidavit in opposition.
because without a judicial order, to treat your IE as an affidavit would not be otherwise
My-
permissible.
My second petition is also there. Madam.
Fine, that's okay.
It may be treated.
No. Unless this is a judicial order, that's okay. Otherwise, I find it very difficult. There is no judicial order. to that
And
effect.
it may be treated, madam.
No, it can't be treated.
Then madam, my second petition also there.
No, that is okay, but it can't be treated.
Then I'll say adopted the affidavit filed by the respondent 4 and 5.
Yes,
So for the first petition, my senior will reply, but second petition, my lord. And second petition, I challenge the order passed by the deputy commissioners.
yes,
The deputy commissioner has, without hearing me and also without hearing the president of the selection committee, my lord, give the mark 1 mark, my lord. He has no authority. Already a decision has been placed, my friend, in this regards. my lord. So deputy commissioner has no role to play in this matter.
And Lordship, only one more aspect, Lordship. The writ petitioner, my senior Nayar's client, he is working in my school as a computer assistant, Lordship. He's already employed. Lordship. So I could not be biased against him. Having working in my own employee, I can be biased against him.
And moreover, in the writ petition 540, first writ petition, there is no plea of malafide, my lord. Nothing. No one mentioned that selection committee has acted malafide.
Yes, that's right.
Yes, so we close the matter.
One matter, one thing, my lord. If you lordship kindly see the affidavit filed by the respondent of 4 and 5 was filed on May 2017. In paragraph 2, my friend already read out it, my lord. Paragraph 2, my lord.
Yes,
The last part, my lord, bringing it from 2, 5, 6, above 7 lines from the down, my lord.
which page?
Page 2.
Page 2,
Yes, my
okay.
lord. Paragraph
Yes,
2, my lord. To this, the said officer asks the deponent and the members of the selection committee to write down that they have committed wrong in allotting 0 marks, or they will face trouble with their service. Thus, being helpless and as such, as the speech of the officers was more in the nature of comment, the deponent and the members were left with no alternative than to give the rating which was thus given under the duress of the subject. So that undertaking has been given on under compulsion, my lord. Even if it's threatened them, otherwise you will be face trouble.
No, lordship, once you lordship held the deputy credential, this will be
Yes.
immaterial lordship.
So, my lord, no malafide play has been taken in the representation by the petitioner. So my senior's name may be recorded. Like in court, another court, my lord.
yes,
Only 2 points. Malad. With regard to that rule, Malad, wherein 4A1 and 4A3. 4A1, my lord, consists of two posts, LDA and my lord, grade 4. And that has been clarified in 3, my lord. So both have to be read together. And in 3, it's clear LDA would be the written examination and the computer test. Nothing more, my lord. And for grade 4, it's, my lord, interview plus written examination. 1, my lord. And page 59 also, my lord, if my lord reads clause 3 thereof, it's the same thing, my lord. And in the judgment that has been placed of my lord Justice Via of 2017 to GLJ, my lord, therein it is said that the deputy commissioner has no role. I'm not disputing that, my lord. I'm not saying he has a role. I'm not even saying that because of that you should give me 1 mark. What I'm trying to place before my lord is, before approaching this court, there was an occasion for this matter to be dealt with. And therein, a stand was taken by the school authorities, which is not the stand which is before your lordship. Madam. This is a developed stand. And there is no material before your lordship to substantiate that. The Supreme Court judgment also says that the selection committee took note of that. Took note, my lord, you cannot have it note here. You have to have that note somewhere, my lord, that this man's conduct is not good. Individual sheets, one line somewhere, finished. That's enough, my lord. In absence of those, my lord cannot give any credence to that stand. And the interview having required to be taken out, my lord, this has to be done. And even in that Supreme Court case, my lord, Hoshiar Singh, the matter was remanded back. That you hold a fresh interview. Others were kept as it is. Direction was to hold a fresh interview. This is Mahmood's submission.
Good. So you can add Leonard. Senior counsel. Assisted by Mr. R. Islam, Leonard counsel for the petitioner. You have anything to say? Okay. Also, Mr. R. Mazumdar, Leonard, standing counsel for the Secondary Education Department, representing respondent numbers 1, 2, and 3. And Mr. B. Chakravarti, Leonard, counsel for respondent numbers 4 and 5. And Mr. G. N. Savala, Leonard, senior counsel, assisted by Mr. J. Ahmed, Leonard, counsel for the respondent number 6. Next one. The petitioner and the respondent number 6 had both applied for the post of junior assistant oblique LDA in Jaleswar Girls High School, JALESWAR, Girls High School. The authorities had issued call letter to the petitioner to appear in the written test on 20/12/2015, which was later on refixed on 21/1/2016 for the written test and 24/1/2016 for the computer and oral test. Poster.
Can I just?
The case of the petitioner is, although he had fared well in written test, English typing and computer test, but he was given a score of 0 in the oral interview, for which his total score was 44, and that the respondent number 6 was awarded a score of 10 marks in the oral interview. And his total score came to 44.5. Full stop, therefore, comma. As the score given in oral test was 10 marks, which give an advantage of a score of 0.5 marks to the respondent number 6, comma. This petition has been filed with a prayer for quashing the select oblique merit list dated 24/1/2016 issued by the selection committee of Jaleshwar Girls High School, and to direct the respondent authorities to appoint the petitioner to the post of junior assistant within bracket LDA of the said school. Next paragraph. The learned senior counsel for the petitioner has referred to the provision of 8A1 and 8A within bracket 3 of the Assam Secondary Education within bracket provincialization bracket close service rules cover 2003. And has submitted that Viva OC test is not envisaged for the post of junior assistant within bracket LDA bracket goes with comma, which is a class 4 post. Stop. Referring to the statement made in the affidavit in reply by the petitioner. Comment is submitted that complaints against the school authorities for selection and appointment in for selection of LDA assistants. LDA, sorry, we make it LDA, public junior assistant. The deputy commissioner. Gwalpa had taken our proceedings and by order dated 11/2/2016, the Institute of Deputy Commissioner, right, District Magistrate, Gwalpa, and the said authority by order dated 11/2/2016 found fault with the award of marks in the oral interview and opined that at least 1 mark should have been given to the given to all the candidates for the personal appearance before the selection committee. after crossing all selection criteria. And accordingly, the said authority directed that 1 mark be awarded to the 3 candidates, who were otherwise awarded 0 marks in the Viva Voce test. Full stop. It is submitted that the petitioner had also obtained a RTA reply from the full stop, it says that the 11th senior counsel for the petitioner has referred to the affidavit in reply filed by the petitioner on 21/3/2017. And it is submitted that on 29/1/2016, in the proceedings before the Deputy Commissioner of the District Magistrate Gwalpara, the selection committee members, namely Abu Taleb, ABU TALEB, in charge headmaster, member secretary, Shariful Islam, SHARIFUL, Islam, assistant teacher, and Abdul Kader Khan, ABDUL KADER Khan, parent member of SMDC of Jaleshwar Girls High School, had made a confessional statement on 29/1/2016 that by mistake, they had awarded 0 marks to them, to the candidates. Including the second candidate, i.e. the petitioner, who had given correct answers to the question put to him. Just it is submitted that thereafter there was a change in stance by the headmaster in an affidavit filed on 8/5/2017 on behalf of respondent numbers 4 and 5. To the effect that the said statement was given before the officer, probably of the rank of additional deputy commissioner, to admit having committed wrong or faced trouble in their service. And accordingly, it is submitted that full stop. It is submitted that the change in stand, that such a statement was made under threat and coercion is not supported by the stand taken in the readings of WPC 2331 of 2016. Accordingly, comment is submitted that as the interview process was not in accordance with law, blacklist be interfered with in terms of the clear made in the regulation. Next paragraph. For contra command, the learned counsel for respondent numbers 4 and 5 has submitted that all the candidates were duly informed about that they would have to undergo written test, computer test, and interview. And it is submitted that interview is advised under rule 4 within bracket A within bracket 1. 1 means I, small I. First off, referring to the documents appended to the affidavit in opposition, filed by respondent numbers 4 and 5 on 9/3/2017, it is submitted that the written test, computer test, as well as the oral interview were held at held on 24/1/2016 at PR Government, P full stop, R full stop, Government GOVT, full stop, HS and MP School, Goalpara, which was an independent venue. And that the set test and interview was held under the direct supervision of the Inspector of Schools, Goalpara. First off, it is submitted that the stand of the respondents in their respondent numbers 4 and 5 in their affidavit in opposition is to the effect that the petitioner had misbehaved during the interview process and could not answer the questions and had left the interview midway. Why it is permissible to award 0 marks. First off, in this connection, Reliance is based on the case of Hoshiar Singh, HOSHIAR Singh versus State of Haryana, 1993, supply SUPB within bracket 4 bracket closed, SCC 377. Next one, it is further submitted that this court in the case of Lina Bora, LEENA BORAH versus State of Assam and others, 2017, within bracket 2 bracket closed, GLJ 451. Have held that the Deputy Commissioner is not a competent authority in the matter of selection of non-teaching staff under the provisions of the Assam Secondary Education. No, sorry, it's Assam Secondary, within bracket provisionalization, bracket to service rules, 2003. Therefore, the Deputy Commissioner of the District Magistrate, Goalpara, had no authority to take up the proceedings and issue a direction to award 1 marks to the petitioner and 2 others. Referring to the case of Suman Kantipal, SUMAN KANTIPAL versus State of Tripura and others, 2016, legal LEGAL EAGLE within bracket 3 TRI bracket close 311. This Jairuddin also same.
There is on the ground lordship that having participated lordship
Ah,
and
that's-
on the
that's right.
interference part also.
Okay.
Mark allotted by the
Okay.
Newly
And
constituted board, Lordship.
and Jahiruddin Ahmed, Jahiruddi Ahmed was the state of Assam and others. Comma, within bracket 2014. Bracket closed 4GLR 483. Comma, it is submitted that having subjected himself to interview, comma, it is not open to the petitioner to turn around and question the selection process of having been awarded marks in the Viva test. Next one. The learned senior counsel for the respondent number 6. Has made submission similar to the submissions made by learned counsel for respondent numbers 4 and 5. First one. Next one. Consider the materials available on record, as well as the submissions made by learned senior counsel for petitioner, respondent number 6, as well as learned standing counsel for respondent number 1 and 2, as well as 4 and 5. 3, nobody is appearing. 3 is. I think 1, 2, and 3 will be secondary education.
Yes.
1, 2, 3 will be standing council education, like a level.
1, 2, and 3 will be. Okay.
I'm sorry, my lord.
Apart from when our additional argument is, my lord, there is no play has been taken in the return regarding Melavedi, the selection committee. That play is not there.
In the present case in hand, the respondent numbers 4 and 5 had filed their affidavit in opposition on 9/3/2017. So in para 5 thereof, it has been specifically stated that the petitioner had failed to give a proper reply during the course of interaction in the interview process and started to behave in a very indecent manner and was immodest towards the members of the selection committee members and had also left the interview process midway. First one, the statement made in paragraph 5 is quoted below. This is page 54. In the affidavit in reply filed by the petitioner on 21/3/2017, the petitioner has produced a copy of a purported confessional statement signed by stated above, Abu Taleb, Shariful Islam, and Abdul Qadir Khan. The purported confessional statement is quoted below. That is page 72. You just say that the English type copy thereof is quoted below. Thereafter, the said Abdul Taleb, Muhammad Abu Taleb, who was the headmaster of the said school, filed another affidavit on 8/5/2017 on behalf of respondent numbers 4 and 5. Wherein it has been stated to the effect that they had made the confession statement under duress. First of all, the statement made in paragraph 2 thereof is quoted below. That is page 80. First of all. Next one. The question as to whether the proceedings before the district magistrate of the deputy commissioner of Malpara was permissible or not would be adverted to later. So nonetheless, this Mr. Chakravarti, come to page 31 of the writ petition. How many members are there in this, what you call this selection committee? Page 31.
Four persons.
4 persons
President, member secretary, and there are the two other persons.
from the Copy of-
Here from page 31.
is from copy of final merit list 2016. Within bracket annexure numerical 5 of the writ petition, it appears that 4 persons were in the selection committee, namely the president of the selection committee, member secretary of the schools of the selection committee, one Abdul Kadir Khan and Shariful Islam, SHRIFUL Islam. First of- out of the out of 4 members selection committee, 3 of them, namely Abu Taleb, Shariful Islam, and Abdul Qadir Khan, had admitted that they had given 0 marks to the petitioner by mistake. Full stop. The said statement was given before the deputy commissioner of the the district magistrate Goalpara on 29/1/2016. Full stop. The said statement has not been retracted at the earliest point of time. In an appropriate manner. First of all, therefore, it is too late in the day for the respondent numbers 4 and 5 to retract this statement. By filing an affidavit on behalf of respondent numbers 4 and 5 on 8/5/2017. Full stop. The reason for not accepting the retraction made by the affidavit filed by respondent numbers 4 and 5 on 8/5/2017 is because the retraction, if any, can only be attributed to Muhammad Abu Talib, but it would not be a retraction on behalf of Shoriful Islam, SHORIFUL Islam, and Abdul ABDUL Kadir Khan. As they said, affidavit dated filed on 8/5/2017 does not contain authorization of the said persons to the said Muhammad Abu Talib to retract their statement given on 29/1/2016 before the district magistrate of the deputy commissioner in Goalpara. Next paragraph. And the issue of the deputy commissioner, Goalpara taking up the proceedings as district magistrate Goalpara in the matter of selection to the post of junior assistant within bracket LDA in Jaleshwar Girls High School, the court does not find any provision in the Assam Secondary Education within bracket provincialization, bracket course service rules. Two 2003. Post. Therefore, the proceedings drawn up by the deputy commissioner of the district magistrate Goalpara in connection with the selection of junior assistant within bracket LDA would be without jurisdiction. First up. In this regard. The court is inclined to follow the decision of this court in the case of Lina Bora within brackets Super. First one, therefore, comma, the proceedings before the deputy commissioner of the district magistrate Goalpara being honest in the eye of law, comma, the lack of jurisdiction would also vitiate the confessional statement made by the three hearing before effort persons on 29/1/2016. Next paragraph. Insofar as the stand taken by the respondent numbers 4 and 5 regarding the conduct of the petitioner in the interview held on (24 1 2016) is concerned, comma, the court finds that in the final merit list 2016, prepared on 24 1 2016, comma, although 4 members of the selection committee had put their signature, comma, but none of the selection committee members made any remark to the effect that the petitioner had misbehaved with them, did not answer their questions, or that he had left the interview midway. Full stop. As the final merit list dated 24 1 2016 did not contain such remark, comma, the stand taken in the affidavit in opposition by the respondents 4 and 5 would merely be an improvement by way of an affidavit, which is not permissible in the absence of any primary evidence to the effect that on primary evidence to the effect that there is any recorded remark in the interview sheet that the petitioner had misconducted himself by in the manner it's stated in paragraph 5 of the affidavit in opposition filed by respondent number 4 and 5. Next paragraph, under such circumstances, comma, the court is inclined to hold that the final merit list prepared on 24 1 2016 does not contain any justification of award of 0 marks to the petitioner who had otherwise fared better than the respondent number 6 in the written test, comma, English typing test and computer test, where both of them secured 25, comma 5 and 14 give a equal sign equal to 44 for the petitioner and 23 half 3 8 oh, no, after 14 in the first 14 0 equal to 44, then 23 half 3 8 10 equal to 44.5. Full stop. Next problem. The learner counsel for respondent number 4 and 5 has referred to the case of Hoshiyar Singh within bracket Supra, where 0 marks was granted by the interview board. The petition therein. Sorry, appellant therein. First of all, in the said case, in para 13 thereof, the Supreme Court of India has observed that if the had observed as follows, the para 13 here. I'll put up like my first. First of all, in this regard, is the final merit list dated 24/1/2016 does not contain any endorsement to the effect that the petitioner had misbehaved at the time of interview. And taking into note the fact that in the first taking into the fact that that the respondent numbers 4 and 5 in the affidavit in opposition has not produced any document to show that the members of the selection committee had made a record anywhere that on 24/1/2016, the petitioner had misbehaved with them, refused to answer the questions and left the interview midway, the stand taken in the affidavit in opposition with the said effect is held to be contrary to the document on record, i.e. the final merit list dated 24/1/2016. Next, accordingly, the court is inclined to hold that the 0 marks granted to the petitioner in the oral interview, public biography test, would not be justified by the respondent numbers 4 and 5. Accordingly, insofar as the oral oblique biopsy test is concerned, it would be appropriate to remand the matter to the selection committee of the Jaleswar Girls High School to have a fresh interview held for the said post. By inviting all. By inviting, by giving a contact to all the candidates. Next part. Insofar as the lead taken by the senior counsel to the petitioner that the Assam Secondary Education within bracket provincialization bracket post service rules, 2003 does not envisage holding of biopsy test for the post of junior assistant at LDA. Post of, the court finds that contrary to the finds that on a conjoint reading of rule 4A (1) and 4A(3). This 1 and 3 is Roman. Comma. Rule 43 does not envisage so this what do you call this this LDA's lower division assistant along with typewriting test and written test along with Viva VOC for class 4 post. So that is junior assistant is Viva VOC.
No, plus junior assistant is the same rank in LDA.
No, it's
Not
no, sir. Nair was reading 4.3.
Yes, sir.
4.3 says after receipt of candidates from so and so to hold written test for selection of lower division assistant along with typewriting test and written test along with Viva VOC for class 4 post.
Yes.
So Viva VOC is inherent.
No, my lord, the shall inform the school committee to hold the selection for selection of lower division assistant along with typewriting test and typewriting test.
But LDA is grade 4.
And then no, my lord, grade 4. LDA is grade 3.
LDA is grade 3.
Yes. LDA junior assistant is same rank, grade 3. My lord. LDA not grade 4. Then and written test along with Viva VOC for class.
Mr. Saiwala?
My lord, it appears, my lord, that LDA has to appear typewriting test.
Okay. So that
Because your losses may see
for the purpose of selection of lower division assistant, the requirement is to hold written test
along with Viva VOC.
along with typewriting test.
Yes, yes.
And that The written test along with Viva VOC is envisaged for class 4 posts. Most of the provision of Rule 4A1 and 4A3 are quoted below. Next one, be that as it may. In the present case in hand, it is noted that on 15/1/2016, a notice was hanged in the notice board envisaging oral test for the post of junior assistant within bracket LDA. Post of therefore, comma. As you said, requirement to hold an oral test was never objected to. Comma. In respect of this case in hand, comma, the court is not inclined to waive off the requirement of holding an interview, though the same is not strictly in accordance with Rule 4A3. Full stop. The petitioner, having subjected himself to the Viva VOC test, would not suffer any prejudice if the Viva VOC test is held again. Next one, accordingly, comma. In view of the discussions above, comma, this writ petition stands partly allowed.
The press advertisement issue. The press advertisement is issued, madam, for Bhaga VOC. Press notice.
Press notice.
Press notice.
Uh,
The press. Press. Press.
partly allowed by setting aside from question of the impugned select public merit list dated 24/1/2016. Prepared by the selection committee of Jaleshwar Girls High School. Most of the authorities of the Jaleshwar Girls High School, Jaleshwar, is directed to hold a fresh Viva VOC test for all the candidates whose name appear in the select list dated 24/1/2016 by issuing them a fresh notice and fixing a venue and time for the interview. Yes. Do we now require all those what you call video recording and all everything?
I leave it to
No, I am asking you.
whether you will behave properly or not this time.
Okay. Said exercise shall be completed within an outer period of 2 months from the date of this order.
Much of
Now, second petition. We had both the writ petitions together. Huh? In para 2, we have given the facts of WBC 540 of 2016. Make para 3 where these are facts of WBC 2331 of 2016. Give a heading, WBC 2331 of 2016. Say the respondent number 6 in WBC 540 of 2016 is the petitioner in WBC 2331 of 2016 and agreed by the directions given by the district magistrate of the Deputy Commissioner Gwalpara by his order dated 11/2/2016 to award 1 marks to those candidates who had been awarded 0. The present rate petition has been filed under Article 226 of the Constitution of India, challenging the said impugned order dated 11/2/2016. Then head there, for the sake of convenience, as both the writ petitions are taken up together, the petitioner herein is also is referred to as respondent number 6 for the sake of convenience. Then the last, come to the last, next one. In view of the discussions above, as this court has already held, by following the decision of this court in the case of Lina Bora within bracket Supra, that the Deputy Commissioner of the District Magistrate Gwalpara had not vested with any, was not vested with any jurisdiction to take up a proceedings arising out of the selection committee decision dated 24/1/2016 in the manner which it, with manner in which it was done, or the same being contrary to the procedure prescribed in the Assam Secondary Education within bracket Consideration Act 2003, which prescribes no role to the Deputy Commissioner in adjudicating, in entering into an adjudication as to the correctness or otherwise of the select list prepared by the school authorities. The court has no hesitation in setting aside and quashing of the impugned order dated 11 to 2016. In a case captioned complaints on recruitment of LD assistants. Instituted and taken up by the District Magistrate Gwalpara. Next, you add there, so accordingly, in the in the holding of a fresh interview, the selection committee shall not be influenced by the contents of the order dated 11/2/2016.
Much of this. In the next petition, I have entered my appearance on behalf of respondent number 8. 2331.
Oh, okay, I like that. In the first, second paragraph, where you have written about 2331, there you add one line. Mr. I'll record your name or
Yes,
your senior's name?
fine.
Your name.
Yes.
Mr. R. Islam has entered appearance on behalf of
Respondent number 8.
respondent number 8,
That is
who is the
petitioner
rate
in
petitioner,
first.
who is the rate petitioner in WBC
540.
540/2016. Just add this in paragraph 3. Okay.
Much. My name is on for respondent 6.
Yes, I have recorded. I don't think we'll have time for any other matter. Mr. Chakravarti, these citations you can collect tomorrow. Let the transcription be made. I, if any pending, is disposed of. This book you can take back. You have given a photocopy. Only the printout citations will get tomorrow.
Second floor.
Hello. ঠিক আছে। লাইটটো stop কৰি দিয়ক। Stop কৰি দিয়ক, কৰি দিয়া নাই।